you can speak, you have oxygen in your brain. At 8:24:09, he again verbalizes, please, I can't breathe, indicating at 8:24:09 that his brain has oxygen and there is no impairment to his airway. 39 seconds later, Mr. Floyd goes limp at 8:24:48. Person can hold their breath for 39 seconds, right? That does not result in hypoxia in 39 seconds. 27 seconds later, according to Dr. Tobin, Mr. Floyd takes his last breath. It's a total of 66 seconds, 1 minute and 6 seconds from the time that we know there's enough oxygen in his brain to speak. No occlusion to the airway at that point. 66 seconds from his last word to his last breath. This timeline is consistent with a sudden cardiac arrhythmia. It is not consistent with the longer process of brain hypoxia. Dr. Fowler's final analysis was that Mr. Floyd died from a cardiac arrhythmia due to atherosclerotic and hypertensive cardiovascular disease during restraint by police. Other significant factors: fentanyl intoxication, methamphetamine intoxication, possible CO, carbon monoxide exposure, and the paraganglioma. What role did carbon monoxide play in Mr. Floyd's death? We don't know. Nothing was ever tested as far as the vehicle is concerned. We don't know if the car was emitting carbon monoxide. We don't know. One thing we do know is that it was running. And how can we tell that it was running? Because in the video we watched earlier, when Thomas Lane pulls in that squad car at Cup Foods, he puts it in gear, he takes it out of gear, he puts it in park, he never touches the keys of that vehicle, and he gets out. The car was running. I have one last point to make, and I should be fairly quick with this. The superseding cause that was discussed. A superseding cause is a cause that comes after the defendant's acts, alters the natural sequence of events, and is the sole cause of a result that would not have otherwise occurred. Now, let's look at, we know that EMS was stepped up to code 3 at 8:21:35 seconds. We know that EMS responded to Cup Foods based on the videos at 8:27:27 seconds. We know that EMS called for fire at 20:38:36. It takes approximately 3 minutes for EMS and the arresting officers to put Mr. Floyd into the ambulance, and the ambulance pulls away from Cup Foods at 8:30:17 seconds. Fire responds to Cup Foods at 8:32:59. That's 4 minutes and 15 seconds after they were called. That's pretty close in consideration to the 3-minute expectation of Ms. Hansen. But the ambulance had driven several blocks away to 36 and Park, arriving sometime between 8:31 and 8:33. That's 1.5, and we know that because there are 2 exhibits, 62 and 63, that were introduced. 62 shows 1 paramedic and Officer Lane in the back. 63 shows 2 paramedics and Officer Lane in the back. So somewhere between 1.5 to 3 minutes to get to 36 and Park where they began the resuscitative effort. The first air is pumped into Mr. Floyd, per Dr. Tobin, at 20:35:06. That is 10 minutes after Mr. Floyd went unconscious, per Dr. Tobin, but it is 7 minutes and 46 seconds after EMS responded to Cup Foods. We ultimately know that the
Entertainment news last night proved to be a big one for country stars. From Carrie Underwood to Dwight.
At HCMC at 8:53, shortly after 8:53. So it took about 5 minutes to get from 36 and Park to HCMC. what would have happened if EMS had started resuscitative efforts right away? What would have happened if rather than driving to 36 and Park, they went to the hospital? They would have been there in that time. I am not suggesting to you that the ambulance paramedics did anything wrong. But it raises the prospect of that continued delay in resuscitation. What if EMS had administered Narcan? We heard that it would not have hurt him, and it could have helped him. I'm not blaming the paramedics. More important than this analysis is it shows that human beings make decisions in highly stressful situations that they believe to be right in the very moment it is occurring. There's lots of what ifs that could have happened, what could have happened, what should have happened. Lots of them in lots of regards. We have to analyze this case.
From North Carolina is recognized.
I yield myself such time as I may consume.
Gentlemen.
Of death to determine, did Mr. Floyd die exclusively of asphyxia, or were there other contributing factors that were not the natural result of Mr. Chauvin's acts? Right? Things that happened that were set in motion before Mr. Chauvin ever arrived. The drug ingestion, right? The bad heart, the diseased heart, the hypertension. All of these things existed before Mr. Chauvin arrived. The struggle, what role did the struggle play? We know, based on a prior incident, that Mr. Floyd's heart was beating at 219 over 160 in a situation where he was confronted by police and had ingested drugs. He didn't die that day. All of this, ladies and gentlemen of the jury, all of this, when you take into consideration the presumption of innocence and proof beyond a reasonable doubt, I would submit to you that it is nonsense to suggest none of these other factors had any role. That is not reasonable. And when you, as members of the jury, conclude your analysis of the evidence, when you review the entirety of the evidence, when you review the law as written, and you this all within a thorough, honest analysis, the state has failed to prove its case beyond a reasonable doubt. And therefore, Mr. Chauvin should be found not guilty of all counts. Thank you. Has failed to prove its case beyond a reasonable doubt. And therefore, Mr. Chauvin should be found not guilty of all counts. Thank you.
Members of the jury, there's an issue I need to discuss with lawyers, so we're going to send you back to your room for probably about 5 minutes.
Hi everyone, I'm Nicole Wallace. Watching along with us, NBC News correspondent Shaquille Brewster, live for us in Minneapolis. Yamiche Alcindor is with us as well, a PBS NewsHour White House correspondent. Also watching with us, former Missouri Senator and former prosecutor Claire McCaskill, and Michael Eric Dyson is here. He's a distinguished university professor at Vanderbilt. He's the author of the book, A Long Time Coming, Reckoning with Race in America. We hope to get to talk.
Matt, so you probably just saw there that Eric Nelson, the defense attorney for Derek Chauvin, just wrapped up arguments. I think the judge just said he had some discussion. Yeah, we're just going to go and take a listen now and see what's going on. The judge is talking. I think we're going to...
Single American. Unfortunately, some of last summer's demonstrations have devolved
from hucksters and scam artists
I'd like to thank my good friend, Congressman Trey Hollingsworth.
I believe that the counsel made a misstatement of law when he indicated and argued that the defendant had to intend to apply unlawful force, as in he had to intend that the force he was applying to be unlawful. That's not a correct statement of the law pursuant to Dorn at 887 Northwest 2nd, 826. The state need not show that the defendant meant to or knew that she would violate the law. That is what Mr. Nelson argued before the jury. So we're requesting the court give a curative instruction to the jury as follows: that it is not necessary for the state to prove that the defendant intended to act unlawfully, only that the defendant intentionally applied force to another, that this application of force was unlawful, and that this application of force resulted in bodily harm. I believe that's a correct statement of the law.
Which is contrary to what the court instructed in the first set of instructions.
Your Honor, I believe the court's instruction was that the intentional infliction of bodily harm requires the proof that the defendant intentionally applied unlawful force to another person without that person's consent, and that this act resulted in bodily harm. You did not instruct that the defendant need to intend that his force be unlawful, merely that he intended to apply the force, which was unlawful.
I'm going to deny the request for curative instructions. I will reread before the beginning of rebuttal statements of judge and attorneys, which starts at the bottom of page 2 and goes on to page 3, which specifically states that if an attorney's argument contains any statement of the law that differs from the law, I give you disregard the attorney's statement. I'll reread that, turn over to Mr. Blackwell, who I assume will answer this exact question, or this exact issue in his rebuttal.
We do ask the court's guidance on another issue, and that is Mr. Nelson argued, quote, Mr. Chauvin thought that he was following his training. There was no testimony from Mr. Chauvin, and he didn't argue that they could infer that. He argued that they thought that. Placing that in context puts us in a difficult position in that we can't comment on his failure to testify, but that statement is directly at odds with the evidence in the record.
Mr. Nelson, any response?
Read the quote, Steve.
Mr. Chauvin thought he was following his training.
What was the context there? Yeah. And
Well, it was in your use of force discussion. You were talking about a reasonable officer following his training. You indicated that Mr. Chauvin thought he was following his training.
I don't recall saying it, Your Honor. I mean,
Even if you did, it was drowned out by a reasonable officer. I think it's a reasonable inference to draw from the evidence that exists. Even in a statement, Commissioner McMillan essentially was an indirect way of saying he was following his training. It's a reasonable inference for counsel to argue from the evidence. And to respond to that specifically by saying there's no evidence would in fact be commenting on his right to remain silent. So that by the state is all within, so. But as far as the other issues, you could talk about re-quoting what the elements are on assault in the third degree, and also anything else that you think was a misstatement of law. I will read them, the statements of judges and attorneys if you wish. And actually, before I do that, do you want me to read that? Reread that, or should I?
Yes, Your Honor.
Okay. I don't want to force it on you, but that would be my, just to remind them that it.
If you're on that jury, what are you thinking?
If you're in that jury right now, Kate, you're wondering how much longer this is going to go on. We're talking about these lawyers talking for a long time individually, and let's just be real. People don't listen to their preachers for 45 minutes, let alone speeches from lawyers that go on for hours. At this point, we're talking about, over 4 hours of listening to people speak? So I think what needs to happen here is each side needs to wrap it up, try to keep things tight. I think the defense has not done a great job, but remember, they don't have to do a great job. They just have to appeal to one juror who will hold things up. I think that's what they are trying to do. And I don't think it,
Back.
Judge Cahill, they're talking to the request of the prosecution to restate what he had said earlier about causation, that this would have to be a substantial factor, the need of the neck, not the sole cause, but a substantial factor.
Principal argument in terms of contradicting the defense argument. The state made comments about essentially about the nonsense of the defense in this case, and it is improper.
I know what you're going to say. We'll hold that thought. All right, be seated.
Just a
They had made it someone.
Mr. Blackwell, you may get state rebuttal. Members of the jury, before Mr. Blackwell begins, I'm going to reread one of the instructions. And that is specifically that attorneys are officers of the court, and it is their duty to make objections they think proper and to argue their client's cause. However, the arguments or other remarks of an attorney are not evidence. If the attorneys or I have made or should make any statement as to what the evidence is that differs from your recollection of the evidence, you should disregard that statement and rely solely on your own memory. If an attorney's argument contains any statement of the law that differs from the law I give you, disregard the attorney's statement. Mr. Blackwell.
Thank you, Honor. Good afternoon, ladies and gentlemen. Last lawyer, I think, talking to you with closings will be me, and I won't be too long. I want to start talking to you about what I call the 46th witness. You actually have heard from 45 witnesses on the stand, but there is a 46th witness. And this witness was testifying to you before you got here to the courtroom. They testified over everybody else's testimony on the stand. It's the only witness that will be talking to you when you're back in deliberation. And that witness, ladies and gentlemen, is common sense. Common sense. We'll continue talking with you all the while, because while you've heard hours and hours and hours of discussions here in the closing, ultimately it really isn't that complicated in what it is you have to decide with respect to the excessive use of force and the issue of causation. In fact,
I want to tell you that I was touched, personally touched.
Who is handcuffed, who is not resisting, who is not breathing, who doesn't have a pulse, and to go on and do that for another 3+ minutes before the ambulance shows up, and then to continue doing it. Handcuffed, who is not resisting, who is not breathing, who doesn't have a pulse, and to go on and do that for another 3+ minutes before the ambulance shows up, and then to continue doing it. How is that a reasonable exercise in the use of force? You can believe your eyes, ladies and gentlemen. It was what you thought it was. It was what you saw. It was homicide. Now, Mr. Nelson spent quite a bit of time saying to you, perform an honest assessment. Look at all the evidence. Consider all of it. Reasonable officer. Reasonable officer is not magic words that you simply apply to Mr. Chauvin, and then he becomes a reasonable officer because you applied those words. Reasonable is as reasonable does. And here what you saw wasn't reasonable, and you didn't get the whole truth. Notice how when you had the discussion about reasonable officer, Mr. Chauvin, the whole narrative cut off before we got to the point that Mr. Floyd was not moving, that he was not conscious, that he didn't have a pulse, and that Mr. Chauvin was still on top of him even when the EMTs showed up, and he still didn't get off of him. How is that what a reasonable officer does? And then if you look at the totality of the circumstances, which you heard so much about, what does that tell you exactly where he was coming from? If we're talking about reasonable officer. Now, you heard any number of other things that and looking at the totality of circumstances and trying to do an honest assessment, you didn't get the whole story either. You got bits and pieces and parts. And I call them a story, ladies and gentlemen, because it's either completely not true or the facts have been altered in order to make a point to you, which also makes it a story. What you're going to reach when you all deliberate is a verdict. Verdict is a Latin word that means the truth. You're not going to reach a story when all is said and done. You're beginning at the truths. Why are we engaged in telling stories when we've heard evidence, facts from the stand? Why is that? But you just heard a number of them. I'll give you a few examples of the stories. In studies, after everything you've heard, you already know now that not a single one of those studies ever examined anybody who had a knee on the neck. You know that. You also know that about these so-called prone studies, none of them actually measured what was the oxygen reserve. That is, how is the oxygen actually being affected by putting somebody in the prone position and any amount of weight on it? Would that be even measured? You know that too, although that wasn't brought up. You've been told about the studies to show that the prone position is safe. You heard again about excited delirium. There was not a single witness who sat in that chair and gave you testimony under oath who told you that they felt that Mr. George Floyd suffered from excited delirium. Not one. One of the criteria for excited delirium is the person's impervious to pain. They don't feel pain. They're not people saying my neck hurts, my knee hurts, everything hurts. They're not grimacing because the wrist hurts for excited delirium. That's a fact. If that's a fact, why are we talking about it? Why isn't that said if you're going to be hearing about excited delirium? Then we turn to Dr. Baker, for example, where there's a discussion of homicide, and you were told that homicide was a medical term. That's not what Dr. Baker said. Dr. Baker said homicide means killed at the hands of another, means at the hands of another, is what homicide means. At the hands of another. And he was pretty clear in discussing the cause of death. He said it was cardiopulmonary arrest, complicating law enforcement, subdual, restraint, and neck compression. And he... How about a park? In the environment of. So it reads as though it's called cardiopulmonary arrest in the environment of law enforcement, subdual, restraint, and neck compression. What you were just told, and that was attributed to Dr. Baker, is that somehow he meant that this was an unexpected result. It was an unexpected result of the law enforcement subdual, restraint, and neck subdual, restraint, and neck compression. Dr. Baker didn't come in and talk to any of us about use of force by police officers. He's not in the mind of any police officer. It is not what he said. They were simply words that were put into his mouth, but you check your notes on what his testimony actually was, and you see that that wasn't it. You've heard now for the umpteenth time in this trial, what is the evidence on autopsy for asphyxia? You're looking at the body tissues. You've heard it from witness after witness on the stand. I even pulled out big, giant, thick textbooks that even Dr. Fowler, the defense own expert, says these are reliable authority. Every one of them says that in half or better of the cases where somebody has clearly died from insufficient oxygen, you don't see any evidence in the body tissues. Ladies and gentlemen, that's a fact. Now, if this is supposed to be about performing an honest assessment, looking at the totality of the evidence, how is that not mentioned to you in summarizing the evidence? How is it not mentioned to you? And I can't even stop there, because you were also told about the law that applies to this. You first told by Judge KELO, and no question that was accurate. But then you were told by Mr. Nelson, no question, that was not accurate. I'll tell you what I mean. KELO, and no question that was accurate. But then you were told by Mr. Nelson, no question, that was not accurate. I'll tell you what I mean. When he was talking about causation, and he talks about fentanyl, heart failure, hypertension, and he said that we have to show beyond a reasonable doubt that none of these other factors played a role. That's not the law. And you don't have to believe me. You'll be able to read it yourself. You'll have the instructions there and see if Mr. Blackwell isn't telling you the truth. That what we need to show is that the defendant's actions were a substantial causal factor in his death. Doesn't have to be the only causal factor. Doesn't have to be the biggest substantial factor. It just has to be one of them. A substantial factor in the cause of death. And the instruction will say that the fact that other causes contribute to the death does not relieve the defendant of criminal liability. There can be other factors. In fact, Dr. Baker had a section, I think, that was called Other Factors, and he was clear. Those other factors are not direct causes of the death. The direct cause was cardiopulmonary arrest that was in the environment of the police, subdual, restraint, and neck compression. Point blank. When I got back and got it to question again after Mr. Nelson was finished, all I did was ask him about what he had written in his certificate on the case. Cause of death, cardiopulmonary arrest. Manner of death, homicide at the hands of another. He was crystal clear on it. He did not equivocate. But what you have gotten here is a number of what I call stories that once you analyze them and you once you analyze them and against the facts and the evidence that you've heard, you'll see what I mean. Take, for example, the notion that Mr. Floyd dying of cardiopulmonary arrest, dying from low oxygen, was just coincidental. He just happened to die at the same time, in the same place, of factors completely unrelated to what Mr. Chauvin was doing with his subdual, restraint, and neck compression. That's a story, ladies and gentlemen, and defies common sense. I'll show you what I mean. Oh, sorry. He was born October 14th, 1973, and just made it a dot on a page. And we looked at over his lifetime. You'll see here, if we look over 10 years, 20, 30, 40 years, up to May 25th of 2020, that means that Mr. Floyd would have lived up to that day 17,026 days. Now, only one of these dots corresponds to May 25th. Only one of them. All the rest of these days, all the rest of these dots represent days that Mr. Floyd was living. He was breathing. He had a being. He was living. He was breathing and had a being with every single disorder that Mr. Nelson has chronicled. Each and every day. You know, with his struggles with opioid addiction, with his high blood pressure, etc. Every single day, except the one day. May 25th, that tiny little speck of a dot, and not even that whole day. Because as we know, there was a 10-minute segment, 9 minutes and 29 seconds, that he didn't survive. So in one day's time, there are 144 of those, 10-minute segments. And only one of them was the reason that Mr. Floyd failed to survive. And what happened in that space? Well, you know what happened. Ladies and gentlemen, that's where there was deadly force applied by Mr. Chauvin. We know it was deadly force because we heard from Officer Zimmerman on the stand, who told us it was deadly force. He said it's deadly force because it's force capable of killing a person, which makes it deadly force. Now, deadly force, ladies and gentlemen, once you see what Mr. Floyd was subjected to with this deadly force in the prone position, there are certain consequences or the risks that come with the prone position and the use of this kind of deadly force. And that primary risk is it affects your breathing. You heard that from witness after witness after witness. It affects your breathing, makes it harder to breathe. You put the subject into the prone recovery position as soon as possible because you don't want to affect their breathing, low oxygen. Subject into the prone recovery position as soon as possible because you don't want to affect their breathing low oxygen. Do you have evidence of low oxygen here? There is evidence of low oxygen, ladies and gentlemen, that is medically unassailable, medically. Take, for example, the fact that Mr. Floyd had an anoxic seizure. That is, he's already unconscious, not breathing, and the body is simply having a twitching reflex. That anoxic seizure represents low oxygen to the brain. And that is what causes the anoxic seizure. But not only that, he suffered from, remember, PEA. And you remember we talked about the PEA, the pulseless electrical activity, PEA? The common cause of PEA is low oxygen. You can't fake it. You can't make that up. There's evidence of the low oxygen, and it would have been what would have proceeded from the use of this very kind of deadly force. And this deadly force took place, as we know, within the 9 minutes and 29 seconds. Now, you heard the statement that the state is seeking to ignore significant medical issues, and nothing could be further from the truth.
Allowing all cannabis-related business.
We need to show that set off a number of things medically for Mr. Floyd that culminated in his death. Remember, he died of cardiopulmonary arrest. That means the heart has stopped and he's no longer breathing. Now, Dr. Baker will tell you that this stress to which Mr. Floyd was subjected in the subdual and the restraint by Mr. Chauvin and others was enough in, of, and by itself to explain Mr. Floyd's demise. When asked the question, what about his oxygen levels? Did he have insufficient oxygen? That's not something I can calculate as a forensic pathologist, said Dr. Baker. That's not something I can calculate as a forensic pathologist, said Dr. Fowler. And Dr. Thomas said the same thing. But the doctor, they said they would defer to pulmonologists in every case, which is who and what we have in Dr. Tobin, who did the calculations, who could tell you how much oxygen was in Mr. Floyd's body. And not only that, he could tell you that when he's put into the prone position, that his oxygen would have decreased by 24%. Who could tell you how much oxygen was in Mr. Floyd's body. And not only that, he could tell you that when he's put into the prone position, that his oxygen would have decreased by 24%. He can tell you that when weight was put on Mr. Floyd's back, the oxygen diminished to 43%. He can tell you that with the weight on his back, that the hypopharynx would have narrowed to 15% or lower, making it difficult for anyone to breathe through. He was able to tell you medically, scientifically, not only could Mr. Floyd not have survived this diminution in oxygen reserves and supply, but no human being could have survived, based on the science. Based on the science. Now, if it's dismissed as theoretical, which is a word I think I heard, theoretical, well, it's the same theoretical that Dr. Fowler said that he would defer to someone else to create because he can't do it. And that's exactly what Dr. Tobin did. And so here, ladies and gentlemen, we're only required to show you that Mr. Chauvin's conduct was a substantial cause, a substantial factor in Mr. Floyd's death. Did he simply die automatically from and exclusively from the low oxygen? Ultimately, the low oxygen translates into not breathing and the heart stopping because we have cardiopulmonary arrest. Did it first impact the heart, then the heart stopped first? Ultimately, they both stopped because we have cardiopulmonary arrest, all stemming back to the subdual, restraint, and neck compression. And from there, the stresses, the strains of Mr. Floyd's body, the low oxygen, culminated in his ultimate demise and his passing away. So I want to address kind of several other points on the heading of what I think think, are stories that you've heard versus, I think, the truths here. You know, when the case started, I think you all were asked and talked to about there being two sides to every story. Two sides to every story. Which is one of the most dangerous things, I think, about the process of truth, because it suggests that everything is simply reduced to a story. And if it is a story, that means there can be multiple sides to a story, and they can never be a truth or reality, except that what we're about here is getting to the truth, and not simply stories. Now, it is most certainly, for example, for a police officer to take seriously this overarching mission of the police department, embracing the sanctity of life and protection of the public as the highest values. But it is equally wrong. It is equally wrong to take this badge, which is a symbol of a commitment to a higher calling to serve the people, to use this badge as a license to abuse the public, to mistreat the public, to not follow proper procedures, to not render aid when you should administer aid. That's wrong. That's not a story. That's simply wrong. And the only two sides to that would be the W and the G for that being wrong. Now, you have heard statements to the effect of Mr. Chauvin being concerned about the bystanders and about others. Well, if you are looking at the totality of the evidence, you have to bear in mind that at all relevant times here, there were 5 grown men police officers right there. And 4 right there on the scene. And then you got Officer Chang, who was there too. There's a radio to call for backup if they felt it was needed. You didn't hear any evidence about any call for backup at all. Now, there was concern here that Mr. Chauvin was concerned. And I won't say much more about body language than has already been discussed. And you'll decide for yourself whether that was the face of one who was afraid at the time. Because he had all of the power at this point. He had the bullets, guns, he had the mace that he threatened the bystanders with, he had backup, he had the badge, and he had all of it. And what was there to be afraid of here, particularly at this scene? There were 3 high school juniors there and a 2nd grader who was going to the store to get candy. There was a high school senior who was taking her cousin to the store, first responder on the scene. And there was Donald Williams, who wanted nothing more than to try to intervene to try to save Mr. Floyd's life. Mr. Charles McMillan, a 61-year-old man, that if I gave him a name, I would call him the mayor of the neighborhood. He just likes to see what's going on and to look out for things, but he was simply there to try to intervene to try to save Mr. Floyd's life. So this wasn't the face of fear or concern or worry. You've seen what the face of fear and worry looked like that day at that time. That's what fear and worry looked like. When Mr. George Floyd was well aware that with one wrong move of his hand, one turn in the wrong direction, and it could be his last turn, that he could be shot to death over an investigation around a fake $20 bill. That's fear. Now, you're told some stories about the bystanders and the suggestion that they were an unruly crowd. You've gotten to meet them now. You've gotten to meet the 2/3 of ones who were there at that time. I described them earlier as a bouquet of humanity. I call them that because they came in different ages, different genders, different races, and they all came together focused on the one thing, which was they saw that a human being they did not know was suffering, and they wanted to try to intervene to stop the suffering. And in that sense, which was they saw that a human being they did not know was suffering, and they wanted to try to intervene to stop the suffering. And in that sense, they were not only symbols of the love and care we want to encourage, but they were also something more than that. They were also symbols of what it means to respect this badge, because they were in a very difficult spot then. You saw them on the stand almost to the last one in tears. You felt the anguish even a year after the fact. They felt torn between their love for the sanctity of life itself that had them wanting to intervene to try to save Mr. Floyd's life, and on the other hand, their respect for the authority that the badge represents, for the city, for the state. They were torn between. Now, the ultimate proof of this is if those bystanders did not respect this badge, they could very easily have taken the law into their own hands and simply have removed Mr. Chauvin. Then we wouldn't have to have any discussions about how reasonable it was for him to stay on a man's neck who wasn't even breathing. We wouldn't have to have any of these kinds of discussions at all. But none of them did that. None of them did that. Because they respected this badge even if it tore them up inside. None of them did that. Instead, they called the police on the police. Instead, they picked up their phones to memorialize what they were seeing so that it could not be forgotten and so that it could not be misrepresented. Instead, they waited for their day to come in and talk with you. Not, ladies and gentlemen, to tell their story, but to tell the truth. Oh, the crowd was getting more agitated. Earlier in the trial, you hear, oh, they were getting angrier and angrier. As though we can't see somehow what it is they're getting upset around. The fact that a defenseless, helpless man is literally losing his life one breath at a time right in front of them, and there's nothing that they can do. If you love life, you get excited when you see life being taken, when that's your perception. That's what they were excited about. And if they all just simply wanted a donut in watching this, you might wonder what's wrong with it. That's why they were upset. So you felt their pain, you felt their sense of helplessness. What you heard about them was a story, ladies and gentlemen. The stories really are just excuses that get told.
Yeah, the use of the word stories.
The fact of the matter is, ladies and gentlemen, that there can be no excuse for police abuse. And I'll be clear, ladies and gentlemen, I will tell you, if I think there's a fact that's been altered, I will tell you what it is. And that's all I ever mean when I say story. But there's no excuse, ladies and gentlemen, for police abuse. And you've heard any number of these. So let me walk through some of them. So let me walk through some of them. You've heard accounts that the traffic was distracting to Mr. Chauvin. Well, the fact was that you heard from the 911 dispatcher, Jenna Scurry, who was watching the scene. And she said that the officers remained in the same place, in the same positions, for so long on top of the body of Mr. Floyd that she thought the camera was broken and frozen. They weren't distracted. They weren't looking around because they were concerned about being disturbed by the traffic or anything else. They had an officer there, Officer Tao, whose job it was just to fend off and keep away distractions, and could have called others if needed. You've also heard about the paramedics took too long. The paramedics took longer to get there than was planned. Should have been there within 3 minutes. And your common sense will tell you that the mere fact that the paramedics took longer than Mr. Chauvin may have thought is certainly not a reason to either use excessive force or to abuse or to be indifferent to the fact that somebody is no longer breathing and doesn't have a pulse, that the paramedics took too long. You heard about the paraganglioma. The paraganglioma, which was also referred to as an incidentaloma, because that's how rare it is and insignificant it is. The hallmark of a paraganglioma Headaches. Mr. Floyd wasn't reporting headaches. So if you're going to talk about a paraganglioma, why don't you talk about the fact that you know the hallmark is headaches and he didn't have them? If this is about getting at the truth, and as well, performing an honest assessment, if that's what we're doing. Now, other than Mr. Nelson saying that the car was turned on at the time, nobody from that witness stand, from the evidence in this case, said the police car was on. You did hear it was a hybrid vehicle. You know, how are we talking about carbon monoxide with a car that there's no evidence from the stand that the car was even on? If we're going to talk about carbon monoxide and give this a reasonable, honest assessment. But even more to the point about carbon monoxide that you just can't lose sight of. Whose car was it, ladies and gentlemen? That if Mr. Floyd is being subdued on the ground by Mr. Chauvin, and if he puts his face in front of a tailpipe of a car that's spewing out carbon monoxide, why isn't that an unreasonable use of force by an officer? In your custody is in your care. It's not in your custody, I don't care. In your custody is in your care. What reasonable police officer would apprehend someone on the ground, subdue them, and put their face in front of a tailpipe of a car, and then think that's a defense? Custody, I don't care. In your custody is in your care. What reasonable police officer would apprehend someone on the ground, subdue them, and put their face in front of a tailpipe of a car, and then think that's a defense? Here, not particularly fair. There's no evidence the car was ever even on. And you learned all you need to know, which was, if he was suffering from carbon monoxide, as Dr. Tobin told you, you wouldn't be able to get a 98% oxygen saturation from the oxygen they gave him, artificially. You heard about the fentanyl overdose. And with this one, you were just told, oh, earlier that afternoon, he was asleep in the car. Ladies and gentlemen, that's not the hallmark of somebody who dies from a fentanyl overdose. It isn't just that you took a nap and dozed off. If you pass away from a fentanyl overdose, you cannot be awakened. You are in a coma. If people are shaking you, it is to no avail. If we're doing an honest assessment of the facts, looking at the totality of the circumstances, if we're going to talk about fentanyl, death by fentanyl or an overdose, why isn't that said? He does not fit the description of anyone who dies from a fentanyl overdose, and even Dr. Fowler conceded from the stand in terms of what a fentanyl overdose looks like. It does not look like somebody who's saying, I can't breathe, my neck hurts, my back hurts, everything hurts. You know, you can't win. I'm not trying to win. That's not what happens when somebody is suffering or dying from a fentanyl overdose. They are completely non-responsive and not reactive at all. Methamphetamine. Ladies and gentlemen, what meth? There was so little of it that it was below the therapeutic levels that are given. You heard that from the toxicologist, from NMS, the laboratory that Hennepin County sends off the medical examiner pathology, not pathology, but blood samples to test for tox. The pills. Now, in cross-examination on the pills, I brought out the fact that what they were saying was the pill that he was taking in the car was just as likely chewing gum, and showed you just before he was in the car, he was chewing gum in the store, opened his mouth, and saw the same nice substance in his mouth. But here's the deal about the pills. If we're really going to give this an honest assessment of the evidence, why are we talking about pills that are not in the system? We know what's in the bloodstream already. We know he struggles with opioid addiction. Why are we talking about pills that we know were not in George Floyd? Why? You have to decide that for yourself, ladies and gentlemen. Why is that even being brought up when we know what's in his bloodstream? What is the point? Drugs in the car, drugs in the car. And the drugs were one pill. One pill. It was not in George Floyd. And then the suggestion that he was somehow taking it in handcuffs in the police car, which makes no sense. There was no evidence of George Floyd taking any pills in the police car at all. There's a pill found there.
I think people are...
You heard references in talking about Dr. Tobin, in his 46 years of experience studying the way people breathe, but, you know, Mr. Chauvin's not a medical doctor. He doesn't have these years of experience and hours to pour over records. He didn't need it, ladies and gentlemen, because you know who else is not a medical doctor? 9-year-old girl is also not a medical doctor. You didn't need to be a medical doctor to understand that when somebody's saying, I can't breathe, and not just saying it, everything about them is showing that they can't breathe. And when that ends, they just are passed out. You don't need a PhD. You don't need an MD to understand how fundamental breathing is to life. And when somebody's saying, I cannot breathe, and they have passed out, and you're aware that they don't even have a pulse, even a 9-year-old little girl knows it. Get off of them. That's all you needed to know in that case. You, just a couple more of these, because I can't even do them all because there were so many. This concern that George Floyd would somehow come to again. He would come back around again. They'll say, not what we didn't really need superhuman strength, except do them all because there were so many. This concern that George Floyd would somehow come to again. He would come back around again. They'll say, not what we didn't really need superhuman strength, except maybe we really did need superhuman strength because he's got all this extra strength now and he's going to do dastardly things. Now, we heard from 3 medical examiners, ladies and gentlemen. 3 of them. Between the 3 of them, they probably have done close to 15,000 autopsies. And not a single one of them testified about one instance ever where somebody who didn't even have a pulse somehow spontaneously came back to life, broke handcuffs, and rampaged the city. It's the facts of this case, not some other thing. Mr. Floyd didn't even have a pulse. That didn't justify keeping your knee on his neck when you should have been administering CPR and you could have brought it back to life again because you're afraid that he would come to with no pulse and rampage the city. That's the sort of thing you see in Halloween movies, ladies and gentlemen, not in real life. Not in real life. The idea that Mr. Floyd suffered from a sudden death, which is what Dr. Fowler was saying. Now he'll say that Mr. Floyd had a fatal arrhythmia in the end. That's misleading in a way because, as you've heard from doctor after doctor, ultimately everybody dies in the end of a fatal arrhythmia. Everybody dies of cardiopulmonary arrest, the heart stops and the lung stops. Then the last thing that happens is, look, you get an arrhythmia and then that's it. Now, is there any evidence that there was an arrhythmia as the primary cause of his death, unrelated to the subdual, restraint, and neck compression on the ground? Dr. Baker, during the autopsy, didn't even have a need to photograph it intact because it was so normal. Now, Dr. Rich did not say anything akin to George Floyd having a normal heart. That's not what he said. What he said was that he had a strong heart. He had a strong heart. And what he meant by that is that he sees patients all the time who may be in need of transplants, who have serious cardiac disease, and they can't even get a normal blood pressure. And he talked to you about how George Floyd, having lived with this for some time, explains how it is that his body and his the arteries that serve the heart were able to compensate in the case of Mr. Floyd, and such that he did not die of a fatal arrhythmia, and there's no evidence that he died of any kind of a heart abnormality. There's no evidence that he died of any kind of a heart abnormality. Just 2 more of these are things I just want to clarify.
It is. Well, we're
Calling out for his life, whether he was motionless with an anoxic seizure, whether he had no pulse. There was no movements, no split-second decisions, no moment to moment. To the extent you're hearing that as representative of this case, it is not representative of this case, does not meet the facts of this case at all. So the fact of the matter is, ladies and gentlemen, the use of unreasonable force, the unreasonable use of force is an assault. So the fact of the matter is, ladies and gentlemen, the use of unreasonable force, the unreasonable use of force is an assault. Here was an assault and it contributed to the death of Mr. Floyd. Now you were told with respect to the law that the state needs to show that Mr. Chauvin intended to act unlawfully or to break the law. Look at your instructions. That's not accurate. We will, in fact, and we own our burden of showing that he, in fact, acted unlawfully, but not having to prove that he intended to act unlawfully. We need only to show that he intended to do what he did, which was to put the knee on the neck, the knee on the back, and against the shoulder, that it wasn't an accident, and that we will show. And we own that burden. So there really aren't two sides to the story about whether this use of force was unreasonable. It was not authorized by the Minneapolis Police Department. The pressure on Mr. Floyd's neck did affect his ability to breathe, and I know that you were told when Mr. Nelson was just here that this was not a choke, it was not a chokehold, and that Donald Williams had suggested or so testified. And if you remember that testimony, Donald Williams disagreed with him every time and said that was in fact a chokehold, even on the one side, and he explained how that even works. And while Mr. Nelson quibbled with him, Donald Williams never gave that up in his testimony. So there aren't two sides to the story as to the unreasonable use of force. And when Mr. Floyd is saying, please, please, I can't breathe, 27 times in just a few minutes, you saw it when Mr. Chauvin did not let up and we didn't get up. Even when he passed out, not breathing anymore, he doesn't let up or get up. He doesn't let up or get up even then. They have to come up and tap him before he will let up and get up off the body of Mr. George Floyd. And they try to resuscitate him in the ambulance, and they never do. He never regains consciousness. He never breathes again. His heart never pumps again. And Mr. George Floyd was deceased. So finally, ladies and gentlemen, I will sit down in a minute, but I wanted to say to the end what I thought the biggest shading of the big, or what I call story.
In disregard to the phrase shading the truth.
Well, here's what I thought then was the largest departure from here, the evidence. I'll show it to you. You were told, for example, that Mr. Floyd died because his heart was too big. You heard that testimony. And now, having seen all the evidence, having heard all the evidence, you know the truth. And the truth of the matter is that the reason George Floyd is dead is because Mr. Chauvin's heart was too small.
The jury could grab your instructions again. Turn to page 11.
Members of the jury, if you have any question about any part of the testimony or any legal question after you have retired for your deliberation, please address it to me in writing and give it to the sheriff's deputy with the juror number of your foreperson on the note. It will take some time to answer any questions because I will have to consult with your lawyers and receive their input before answering your question.
I do not say this to discourage questions, but only to advise you that it will take some time to provide you with an answer. As I told you, you will take with you into the jury room copies of the instructions that I am reading to you. The lawyers and I have determined that these instructions contain all the laws that are necessary for you to know in order to decide the case. I cannot give you a trial transcript. No such transcript exists. We count on the jury to rely on its collective memory. You have been allowed to take notes during the trial, and you may take those notes with you into the jury room. You should not consider those notes binding or conclusive, whether they are your notes or those of another juror. The notes should be used as an aid to your memory and not as a substitute for it. It is your recollection of the evidence that should control. You should disregard anything contrary to your recollection that may appear from your own notes or those of another juror. You should not give any greater weight to a particular piece of evidence solely because it is referred to in a note taken by a juror. Now, we all have feelings, assumptions, perceptions, fears, and stereotypes about others. Some biases we are aware of, and others we might not be fully aware of, which is why they are called implicit or unconscious biases. No matter stereotypes about others. Some biases we are aware of, and others we might not be fully aware of, which is why they are called implicit or unconscious biases. No matter how unbiased we think we are, our brains are hardwired to make unconscious decisions. We look at others and filter what they say through the lens of our own personal experience and background. Because we all do this, we often see life and evaluate evidence in a way that tends to favor people who are like ourselves or who have had life experiences like our own. We can also have biases about people like ourselves. One common example is the automatic association of male with career and female with family. Bias can affect our thoughts, how we remember what we see and hear, whom we believe or disbelieve, and how we make important decisions. As jurors, you are being asked to make an important decision in this case. Taking the decision you are making and examine it for bias. Reconsider your first impressions of the people and the evidence in this case. If the people involved in this case were from different backgrounds, for example, richer or poorer, more or less educated, older or younger, or of a different gender, gender identity, race, religion, or sexual orientation, would you still view them and the evidence the same way? 3, listen to one another. You must carefully evaluate the evidence and resist and help each other resist any urge to reach a verdict influenced by bias for or against any party or witness. Each of you have different backgrounds and will be viewing this case in light of your own insights, assumptions, and biases. Listening to different perspectives may help you to better identify the possible effects these hidden biases may have on decision-making. Listening to different perspectives may help you to better identify the possible effects these hidden biases may have on decision-making. And 4, resist jumping to conclusions based on personal likes or dislikes, generalizations, gut feelings, prejudices, sympathies, stereotypes, or unconscious biases. The law demands that you make a fair decision based solely on the evidence, your individual evaluations of that evidence, your reason and common sense, and these instructions. Another, and deliberate with a view towards reaching agreement, if you can do so without violating your individual judgment. You should decide the case for yourself, but only after you have discussed the case with your fellow jurors and have carefully considered their views. You should not hesitate to re-examine your views and change your opinion if you become convinced they are erroneous. But you should not surrender your honest opinion simply because other jurors disagree or merely to reach a verdict. Now, a single verdict form for each count has been prepared for your use, and when you have finished your deliberations and have reached a verdict as to a specific count, the foreperson should mark the appropriate choice on the form with an X, and then date and sign the verdict form, filling in the foreperson's juror number on the indicated line, and then signing the foreperson's name on the second line. And just so you know, the forms look like this. So there's very little to add, just an X, your juror number of the foreperson, and the foreperson signature. And then signing the foreperson's name in the second line. Just so you know, forms look like this. So there's very little to add, just an X, your juror number of the foreperson, and the foreperson signature. The order in which the guilty and not guilty choices appear on the verdict forms is strictly alphabetical and should not in any way be considered as indicating which choice is the correct choice. When all the verdict forms are completed, the forms should be placed in the provided envelope, sealed and given to the deputy who will convey the verdicts to the court. At a time designated by the court, your verdict will be read out loud in the courtroom in your presence. During your deliberations, you must not let bias, prejudice, passion, sympathy, or public opinion influence your decision. You must not consider any consequences or penalties that might follow from your verdict. You must not be biased in favor of or against any party or witness because of his or her disability, gender, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Witness, attorney, or party should not have an effect on the outcome of the case. The state of Minnesota and the defendant have a right to demand, and they do demand, that you will consider and weigh the evidence, apply the law, and reach a just verdict, regardless of what the consequences might be. You must be absolutely fair. Remember that it is fair to find the defendant guilty if the evidence and the law require it. On the other hand, it is fair to find the defendant not guilty if you are not convinced of his guilt beyond a reasonable doubt. Now, members, as judges of the facts, I am certain that you realize that this case is important and serious, and therefore deserves your careful consideration. Deputy?
Ability to enact positive change, and that's what's needed with the outcome in this trial.
Danny Savalas is with us as well from the...
Do you swear that you will keep these jurors together, separate from all other persons, and that you will not allow anyone to communicate with them or overhear their deliberations, that you will not make any comment to them about the law or the facts in this case, and that you will not disclose to anyone except this court anything which you may learn from their deliberations?
I do.
Thank you. Members of the jury, you're going to go with the deputy now back to your usual room, including jurors 96 and 118. You, however, will be diverted to my office. You are our alternate and will not be a part of the deliberations, but I would like to talk to you a little bit. So you can go with the remainder of the jury, but follow the sheriff deputy's instructions. All rise for the jury.
Judge Peter Cahill, Hennepin County Courthouse there in Minneapolis. Just an extraordinary day that we witnessed here, watching this together throughout the day. The closing arguments from both the prosecution and the defense.
We're still on record.
Derek Chauvin, former Minneapolis police officer, charged in the death of George Floyd.
All right, a couple of things. I know the defense was in the process, I think, of making expressing a concern or an objection to counsel's argument belittling the defense. Is that what I correctly perceived that objection? I think we dealt with it sufficiently during the objections during the rebuttal. So there'll be no additional instruction in that regard.
I do believe that it constitutes prosecutorial misconduct and is potentially basis for grounds for a mistrial.
Okay, I think the word nonsense is what you're talking about originally.
Originally, Your Honor, but then in rebuttal there were repeated comments about how we were, and implications that we were shading was one example, that we were creating Halloween stories was another example, that these were stories, and that was a repeated comment. Stated that we misrepresented facts and put words into Dr. Baker's mouth, that we made several statements that they put forth as stories. After the court instructed him to stop using the word stories, he clarified that it's just fabricated facts. And so there were multiple references to that, that we were shading the truth, right? I mean, and again, So, multiple objections. This is essentially governed by State versus McDaniel. The final argument to the jury of prosecutor is governed by a unique set of rules which differ significantly from those governing counsel in civil suits, and even those governing defense counsel in the very same criminal trial. These special rules follow directly from the prosecutor's inherently unique role in the criminal justice system, which mandates that the prosecutor not act as a zealous advocate for criminal punishment, but as the representative of the people in an effort to seek justice.
Up for each other and keeping that spark alive.
Comments, the repeated comments constitute prosecutorial misconduct.
I'll note for the record that I overruled the first objection when Mr. Blackwell used the word story because it was isolated and in its context it did not seem to me to be belittling. However, the continued use of it, I did sustain the ultimate objection that counsel made to the use of the word stories and instructed the jury to disregard it. Also on shading the truth, that I sustained the objection and instructed the jury to disregard it. I'm not making any findings as to whether it was the type of prosecutorial misconduct that would result in a mistrial. I think it was adequately addressed by the court's instruction to disregard. All right. With regard to other matters we have, I think there were some disregarded. I'm not making any findings as to whether it was the type of prosecutorial misconduct that would result in a mistrial. I think it was adequately addressed by the court's instruction to disregard. All right. With regard to other matters we have, I think there were some bench conferences that you want to, that are fairly historical that you wanted to memorialize, but also a new motion based on events this weekend. Mr. Nelson.
Correct, Your Honor. Your Honor, as the court is aware, and as prior to coming into court this morning for closing arguments, we had an in-chambers discussion about events of this weekend, specifically referencing that an elected official, United States congressperson, was making what I interpreted to be, and what I think are reasonably interpreted to be, threats against the sanctity of the jury process, threatening and intimidating the jury, demanding that if there's not a guilty verdict, that there would be further problems. And given the fact that this jury has not been sequestered, it has been my position all along throughout the course of this case that this jury should have been sequestered at the outset. The jury has not been continually told to stay away from media, only media about this case. There is a high probability that members of this jury have seen these comments, are familiar with these comments, and things that have happened throughout the course of this trial. I mean, it's unfortunate that there was another situation that occurred during the course of this trial. But obviously, Your Honor, we also, as I mentioned previously too, one of the jurors does live in the city, Brooklyn Center, as I recall.
Although I think that is the alternate we just dismissed.
I do not believe so.
I thought it was, but go ahead.
Now I'd have to go back and double check my notes. So, Your Honor, I mean, I just think that the sum total of this trial happening in such a public context, number one. Number two, while all of this, the media attention is profound. I admittedly stayed away from 99% of it, but that has required me to stay away from all media. I mean, this case has found its way into even fictional television. Your Honor, there were I was advised of 2 television shows in the course of the past few days that specifically involve references to this particular case and the reactions of the characters in these stories to this particular case. This away from it unless you literally shut off your phone, or you shut off your TV, you shut off your computer, and no such instructions have been given during the course of this trial.
Well, to be fair, in the last few times I've advised them, I told them don't watch the news. Pure and simple.
Right, but if you can't even watch your favorite Thursday night television program, and it comes up, I mean, this is the problem, right? And why I have felt that this jury should have been sequestered from the very beginning. To make that clear. And so I had moved, based on that, this again for a mistrial. The idea is that it is a public trial. I think the court has accomplished that, but the media attention is so profound. It is such a, I mean, it is such a modern comparison. I mean, it's such a modern problem to have where literally I walk from this courtroom into the courtroom where I've been permitted to stay. During the course of this trial, I've received literally thousands and thousands and thousands of emails. So much so that I don't even look at that particular email. So, someone gives me alerts on things that just happened. I mean, you can't avoid it. And it is so pervasive that it is, I just don't know how this jury, it can really be said to be that they are free from the taint of this. And now that we have U.S. representatives threatening acts of violence in relation to this specific case, it's mind-boggling.
Well, I'll give you that Congresswoman Waters may have given you something on appeal that may result in this whole trial being overturned. But what's the state's position?
Your Honor, the state's position, first and foremost, and this is a concern I raised at the beginning of the proceedings, while it's a jury selection, is that we can't allow statements like this, vague statements, to be considered a part of the record on appeal. If there's a specific statement that a specific U.S. representative made, then there needs to be some sort of formal offer of proof with the exact quotes, the exact statement, or some kind of a declaration. I'm sure Mr. Nelson can do that if he thinks that that's something that's appropriate. I don't know that this particular representative made a specified threat of violence. I don't know what the context of the statement is. I also don't know what television shows Mr. Nelson is referring to in terms of any of this. And so I just don't think that we can muddy the record with vague allegations as to things that have happened without very specific evidence that's being offered before the court. As a practical matter, through the jury selection process, the court has provided instructions, has determined whether or not there are any outside influences. The law presumes that the jury follows the judge's instructions, and the court has instructed the jury today that they're not to let any outside influences or public opinion sway their deliberation. And the law presumes that they will be capable of doing that. So without any sort of specific offer of proof or information in the record, without any specific evidence that this particular jury was influenced in any particular way, I believe that the defendant's motion should be denied.
Your Honor, I make my comments, in the context of this is all such an evolving situation. Obviously, I spend my weekend preparing for closing remarks, and I certainly can supplement the record with news articles. I can supplement the record with the storylines of the particular shows that were brought to my attention. So I'm making it to note the record at this particular point, and I can certainly supplement it.
Yeah, you can supplement the record with whatever media reports.
With disabilities.
So that you rack up it was probably a few weeks.
Articles about that. This goes back to what I've been saying from the beginning. I wish elected officials would stop talking about this case, especially in a manner that is disrespectful to the rule of law and to the judicial branch and our function. I think if they want to give their opinions, they should do so in a respectful and in a manner that is consistent with their oath to the Constitution, to respect a co-equal branch of government. Their failure to do so, I think, is abhorrent, but I don't think it has prejudiced us with additional material that would prejudice this jury. They have been told not to watch the news. Constitution, to respect a co-equal branch of government. Their failure to do so, I think, is abhorrent, but I don't think it has prejudiced us with additional material that would prejudice this jury. They have been told not to watch the news. I trust they are following those instructions and that there is not in any way a prejudice to the defendant beyond the articles that we're talking specifically about the facts of this case. A congresswoman's opinion really doesn't matter a whole lot. Anyway, so motion for mistrial is denied. With regard to, there was a report that counsel were made aware of
a few days ago that a juror may have been talking to a major media outlet. We checked with that major, and it appeared right from the beginning that it was third-hand, hearsay, telephone game. That media outlet, in fact, took it very seriously, did a nationwide contact of all of its reporters and staff to check out any veracity, and there apparently is none whatsoever. Nobody from this major media outlet made any contact, and I find that credible, and so just for the record, I pass that along. Now, I think we still have the memorialization, but we also have to talk about a Blakely waiver.
Yes, Your Honor. So a couple of things in terms that we provided our memorandum of the objections that the defense had made at sidebars. I am going to propose, rather than just simply reading through and taking an hour's time, that we submit those objections in writing, that happened, and in consultation with the state in making their objections. We did not.
It'd be nice to include just essentially a stipulated pleading that sets out what the objection was and what the court's ruling. There's no need to repeat what the arguments were. The only thing that you need to preserve for appeal is what the objection was and what the court's ruling is. So I would encourage both parties to get together and figure that out and file it reasonably quickly. It doesn't have to be today, tomorrow, or even the next day. But just to get on it while our memories are fresh.
And if there's a discrepancy between the memories, Your Honor, I'm expecting that we're going to be able to come up with a stipulated document. If there's anything that needs to be set out, we can just indicate our contrary memories of that. Should be pretty simple.
Absolutely. I think that would be the best way to memorialize this in any case. All right. Other than Blakely, do we have any other issues to make a record of?
No, Your Honor, I think we just need to have some administrative discussion. This timing.
And we can do that in the chamber's discussion. All right. With regard to Blakely.
Sure. I have not yet had Mr. Chauvin execute the written waiver. Again, I do have it. You can print it to get that taken care of. But I can do an oral waiver now.
If you would.
For Mr. Chauvin, let me take the mask off. Mr. Chauvin, you're aware that during the course of these proceedings, the state has filed what's called the Blakely notice, or a notice to seek an aggravated sentence, correct? Yes. I have explained to you the bases on which the state is seeking to have an aggravated sentence imposed in the event of a conviction on any one of the counts here, correct? Correct. We've discussed those, and I have specifically advised you that you have a right to have a jury decide whether or not the state has proven those grounds for an aggravated sentence beyond a reasonable doubt. You have a right to have a jury decide if you violate it, right? And I've advised you that the state has to prove those grounds beyond a reasonable doubt. And we can waive that right and allow, if you're convicted, we can waive your right to a trial and allow the judge to make those determinations. I've advised you about that, right? Yes, sir. Now, do you want a jury to make a decision about the proof required for the aggravated factors if there's a conviction, or are you willing to waive your right to a trial on those matters and allow Judge King to make those decisions? I'm willing to waive it and have Judge King decide on those issues.
Mr. Chauvin, again, I'm going to address you individually because this is another one of the decisions verdict form with interrogatories with a question and yes or no options, and that's what generally the jury would consider. In order to say yes, the jury would have to be convinced beyond a reasonable doubt. The burden of proof does not change. It's only that I'm going to be the one who's answering those yes and no questions. It was always true that based on whatever the answers are to those, that I would be the one deciding if they constitute legally substantial and compelling circumstances, and we would expect briefs from both sides on that. Do you understand that?
Yes, sir.
So basically, I will be answering those verdict form questions instead of the jury, applying the standard of proof beyond a reasonable doubt. Is that what you want to have happen?
Yes, sir.
All right. I would ask that you file a written Blakely waiver in addition.
We will, Your Honor.
All right.
I just have a question on the form that was provided, and we can, again, it's an administrative question.
Right. It's an administrative memorialization, so You can do that off the record. In addition.
All right. I just have a question on the form that was provided, and we can, again, it's an administrative question.
Right, it's an administrative memorialization, so you can do that off the record. All right, council, I'm going to talk with basically give instructions to the alternates, give me 20 minutes, and then watch you come on back. All right, otherwise we are in recess until we hear from the jury.
Hi everyone, I'm Nicole Wallace. It's a few minutes after 5 o'clock in the east, a few minutes after 4 o'clock in Minneapolis, where we're watching the end of closing arguments. The jury in the murder trial of Derek Chauvin now has the case. Watching along with us, NBC News correspondent SIOUX Brewster, live for us in Minneapolis. Michelle Cinder's with us. Claire McCaskill still here, as is Michael Eric Dyson. Let me start with you, Claire McCaskill, and I'll get to Maxine Waters in a second. But on this rebuttal that the prosecution made to the defense's closing argument, he really seemed to crystallize what we've all watched for the last several weeks.
What he did was very smart, because what he went back to was the evidence and how it applies, how the law applies to that evidence. And by doing that, they're going to have the law with them in the jury room. They will be able to look at those instructions, and the judges told them over and over again, this written word is all the law you need to know to decide this case. And so by referring to those, it just heightens the credibility of the prosecution, because they can see it in writing. That's what the law is. That they didn't have to prove beyond a reasonable doubt that his heart didn't contribute to the death, or that his drug use didn't contribute to the death. That's not what the law says. And I thought he did. That was the strongest part of the defense's argument, and I thought he obliterated it.
Cause of death, and making clear that the substantial cause of death obviously is the only thing they have to prove. Defense coming back, in my view, I think, in taking far too long. Everyone does this differently, Mike. No one has a monopoly on wisdom. I get that, but I think that it was a missed opportunity. If you're from a defense perspective, what do you want to do? You want to poke your holes. On the issue, what fell hollow to me is that they were deficient with respect to the use of force issue. Why do I say that? I think that was a miss in terms of this distinction between risk and threat, and they failed to really hammer home where Chauvin felt threatened as opposed to where he was simply at risk. I think the prosecution really held him to account in that regard. I think that was a miss. Also, obviously, the prosecutor trying to push it back in time. Push what back in time? Prosecution saying, look at the 9 minutes and 29 seconds. Defense saying it's far greater than that, but them never addressing this issue, they being the defense, this reassessment that's necessary as it relates to force. So I think they failed on that. Where they could have had some traction is on the issue of the medicine. Did they raise enough doubt as to the issue of this toxic brew in his system? It just caused him that day and time specifically to die. Right, and that, I think, is where the jury is really going to be evaluating. Final point, we saw in the rebuttal, which I think was very hard. He went in very hard, that is Mr. Blackwell, really saying don't believe the hype, because you had this issue come out of intellectual dishonesty. Well, you want to talk about intellectual dishonesty, I think Blackwell went in on the fact of saying the paramedics arrived late. Is that really, isn't that dishonest? Going in on the carbon monoxide? By the way, didn't you, Officer Chauvin, put him in the position of having the carbon monoxide? Just going in very hard in that regard, and I think concluding, right, although I could say so much more, in the big heart, right? Let's end it here, Mike. In the big heart, what did Blackwell say, the prosecutor? He said, this is not about the cause of death from being George Chauvin's big heart. It's about the small heart of Chauvin. Riveting, compelling. Jury has the case now. They've been duly instructed. Let's see what they do. If you're the defense, only takes one for a mistrial. You're the prosecution. You have to demonstrate beyond a reasonable doubt to all of those 12 that you've proven the elements beyond a reasonable doubt. We know what the charges are. Very significant here.
Said we've got to get more active, we got to get more confrontational, we've got to make sure that they know that we mean business. What did you make of how that came up at the very end after the jury already began deliberations?
Look, Wolf, come on. This story has been front page news for the greater part of a year. Movie stars, members of Congress, presidents of the United States have commented on this trial. The idea that one member of Congress's statement a few days before the jury starts deliberating is somehow going to prejudice the jury is nonsense. The law presumes that jurors can take in and internalize the instructions from the court, and the court has instructed the jurors, I guess twice, at the beginning and at the end. Number one, not to watch the news, and number two, anything they see to set aside, and they were picked on account of their ability to agree to do so. So some of this, I think, to be candid, is about Maxine Waters, but at the end of the day, one famous person making a comment that's incompatible with the trial just doesn't throw the verdict out. Now, he has to, the defense attorney has to make that objection now in order to be able to make it again on appeal if Chauvin is convicted. So some of that's just basic lawyering, but this is not grounds for a mistrial.
Ali, what did you make of the closing arguments we heard from the prosecution and the defense?
Yeah, so, I think they both did what they had to do. And, the prosecution's goal was to appeal to common sense. One of the things he started off with was, I think you heard, I don't remember the number, I think it's 45 witnesses. The 46th witness is your common sense. And so, yes, you've heard about carbon monoxide, but there's a 9-minute and 20-second video. Yes, you heard about an enlarged heart, but there's a 9-minute and 20-second video. Yes, you heard about fentanyl, but there's a 9+ minute video. And all of these things, the defense did everything they could to throw up bits of doubt, but they just didn't address the 9-minute video. Now, again, that's their obligation. They don't have to, but the common sense plea that the prosecution went to is that big piece of evidence. Now, jurors are weird when they get back in that room, and who knows how they come down. But as a matter of straight presentation, the prosecution just had a more airtight case.
Shan Wu is
this game. Once we
can now get this
Ashes, night sweats, and low end.
in just a few moments. And a reminder to get your late evening news an hour earlier. Dakota News now each night at 9 p.m. on Fox.
Lighting ceiling fans are 11% off, including this.
The chair recognizes the gentleman from New York.
A moment longer. It's time for us to confirm.
But what about the almost 20 minutes before that where he's absorbing information and trying to determine what the right decision is, and they went minute by minute of the decisions he was making when he called the EMT, that he did not escalate force. If he's talking, he's breathing. I'm not justifying it, but the defense did a strong job making a case in front of a jury. 6 minority members, 6 white members. It's not the judge that will make this call. It's not the lawyers that will make this call. It is the jury of peers. And ultimately, that reaffirms a lot of my faith in the system. Yeah. Both Derek Chauvin got a fair trial today. We'll see what happens.
Katie, let me get your general thoughts. And again, just want to remind everybody we're waiting for this press conference that we'll bring to you live.
Well, first, if you watched any number of hours of this trial, and especially the closing arguments today, it's very obvious that what the American people have been told by the majority of the media in terms of this being a clear-cut case is not the case at all. It's complicated, it's nuanced, there's more video than the 9 minutes that we've been shown through social media and through news networks over the past 6 or almost year now. But the reason why the defense asked for a mistrial as a result of Congresswoman Waters' comments is because it's about tainting the jury, because she's intimidating the jury if they were to see that, given that she's in a crowd, that Minneapolis has been under siege. They've seen businesses burned down. People made threats over the weekend. You had one of the use of force witnesses on behalf of the defense. His former home was actually vandalized with animal blood and a pig's head because he's a former police officer. So this intimidation is an issue, especially because the jury was not sequestered away from media. And in a time where social media and these kinds of issues bleed into all of the other news items that we're talking about, into culture as well, it's pretty astonishing that the judge did not require that the jury stay away from media, other than just saying, hey, don't turn on the news. Well, not turning on the news is not the only way people get information.
Yeah,
so
it's everywhere.
We'll see what happens. But real quickly, in terms of what's going to happen with these officials preparing for
leveraging its full weight upon the necks of black people who simply want to do the right thing. Look at the surpassing dignity and the transcendent humanity of George Floyd. He didn't curse them out. Even when he had curse words, it was for his plight and predicament, not against them. Officer, sir, he continually deferred to them in orders and magnitudes of recognition of their humanity, even as they denied him his. Even as Mr. Chauvin, with a callous indifference, with a reckless disregard for this man's life, continued to impose upon him constraint. And so, yes, we can say in the broader sense that Congresswoman Maxine Waters may have muddied the waters, may have spoken out of turn, and I can understand why people would think strategically that is a problem. But imagine the accumulated indignities that black people have borne. Look at the suffering that they have silently observed. Look at the ways in which in other trials they didn't say anything beforehand. They didn't speak their minds beforehand, before the jury deliberated, waiting, hoping and praying that a good outcome would be in the offing. And yet they were unavoidably and inevitably and invariably frustrated. So now here we are as a nation. It is our choice as to whether our hearts will be big enough, our visions will be wide enough to accommodate both the data of our despair, but also to look at the horizon of our hope. And we have a choice to make. And if we make that choice, we can really, as Dr. King said, wring out of the mountain of despair a stone of hope. But it is up to us. It is up to this jury. It is up to us what we will do after this jury. And it's up to the nation. And I'll end by saying this. Isn't it interesting that the defense lawyer basically wanted to police American society, to police American consciousness, to not have Saturday Night Live weigh in? The reason we have other outlets in popular culture, in Saturday Night Live, in fictional engagements, is because sometimes fiction addresses what straightforward nonfiction can't seem to grapple with. We turn to novels, which are made-up worlds of imagination, in order to grapple with the world before us. So what American society has not been able to do, what American jurisprudential rationality hasn't delivered us, what the court systems haven't given to us, maybe Saturday Night Live and other fictional outlets do. Let's not allow fiction to displace our commitment to the fundamental credo of American society, e pluribus unum, out of many one. This is a magnificent moment of reckoning and determination, and I hope we can live up to it.
So, Claire, I just want to bring our viewers up to speed about what we're talking about with Maxine Waters. She made some comments over the weekend. Attorney sought to use as grounds for a mistrial. She said, quote, "I hope we get a verdict that says guilty, guilty, guilty," in response to a reporter's question. She went on to say, quote, "And if we don't, we cannot go away. We've got to stay on the street. We get more active. We've got to get more confrontational. We've got to make sure that they know we mean business." Speaker Nancy Pelosi defended Maxine Waters, said it's the language of the civil rights movement. The defense attorney raised it as grounds for a mistrial, and the judge said this: "I wish elected officials would stay quiet." He called the comments abhorrent. The defense attorney went on, as the professor suggested, to talk about how much is in the news, about this moment in this country. I wonder, none of it happened in front of the jury, but the judge did say you can use that on appeal. What did you hear watching all that with your sort of expert ear and eye in the political world and the legal world?
I heard a defense lawyer who was trying, without much success, to derail this trial as the jury was beginning their deliberations. Now, will he raise these things on appeal? I'm sure he will, if in fact Derek Chauvin is convicted. But the point that I think has been eloquently made is that when you have an event like this and all the events surrounding this in a country where we have freedom of speech, people are going to talk about it. And, you know, was Maxine Waters careful about what she said? No, she wasn't careful. But she also didn't advocate violence. There was nothing she said. Confrontational is what peaceful disobedience is all about. Those kids that sat at the lunch counter, they weren't hitting anyone, or they didn't have an AR-15. They weren't mowing people down with multiple magazines. They were being confrontational. And I think that's what Maxine Waters was referring to. And it's just the right and the media on the right that is trying to twist it into some kind of her, saying, let's all get violent. She didn't say that.
Owners and the potential for disruption. But I think you also have to talk about people who feel like, that was a horrific videotape and you saw a man lose his life. And in fact, what you're hearing now from people who were in the stores, people who own those stores, is they wish they had acted differently and not put George Floyd's life into the hands of the police. I think you have to understand this is, all across America, and it's being reflected in terms of efforts to reform policing. This is a major moment that people feel, especially people of color, that they are not treated as citizens but as suspects based on their skin color and want some kind of change to take place. And I think that's a deeply widespread felt grievance here of the American people, that you have to, of course, have law enforcement. This is not about law enforcement that's good. People want law enforcement in their communities, but they don't want to be abused, and they don't want to be viewed as suspects and treated as criminals. I just think that's a really important point, because we could, of course, we all empathize with someone who has property damage, has an ongoing business that's disrupted, but I think you also have to focus on the larger issue here, which is watching the man kneel on another man's neck without regard. Let's just put race aside, even though we know it's a central factor here. But let's just put it aside for a moment and say that's outrageous.
Can I just ask you one other thing, Juan? Senator Tim Scott of South Carolina had put forward a very comprehensive police reform bill that was roundly rejected.
But Nelson, again, failed to vaccinate the jury to hear what Blackwell had said. So to the extent that Blackwell did deliver some zingers, Nelson should have vaccinated the jury and said to them, look, you're not going to hear from me again. But if he brings up something that wasn't covered by me, ask yourself how I would answer that, and please play that role. Don't let him get away with the statement that's been unanswered. Now, at the end of this is where it got really interesting, with the objections that Nelson made and moving, I guess he sort of moved from mistrial, at least that's the way the judge interpreted the motion. What Nelson should have done is ask the judge to poll the jury. Look, Judge, yeah, I understand the law presumes that they're going to follow instructions, but this isn't a normal case. This is the trial of the 21st century. Poll these jurors. You have a congresswoman, and you agree, Judge, that this congresswoman is out of bounds and shouldn't be saying this, and maybe inciting a riot. So why don't you ask the juries if they are aware of anything, and then Nelson, not in his defense, in the prosecution's defense, could have been more specific about some of the television shows they mentioned. But this is a critical moment here, and Nelson should have pushed the judge to poll the jury. He didn't do that. This judge, I mean, for the most part, I think he's done a decent job, and I think for the first time today, I thought he gave some stability, or at least some support to the defense, properly, that is, by dealing with the mistrial motion and the comments that I brought up earlier, which are appellate issues. The characterization of the defense as storytelling or nonsense. Even the judge brought it up better than Nelson did. And he addressed that. But I think his judge is afraid of what the jury's going to say, and he's more concerned with media coverage or positive media coverage than actually making sure that Chauvin got a fair trial. This judge is the first judge in Minnesota to allow television in the courtroom. He certainly wasn't going to grant a mistrial. That's clear. But that's a problem, and I think it's going to give Chauvin life on appeal. Now, ultimately, he's going to get convicted of everything.
Got it. Joe Jackson, to that point, whether it be the words of Maxine Waters over the weekend or the notion that the prosecution was belittling the defense, do you think Eric Nelson's got some good arguments?
No. Okay, no, I don't. Look, Congress people are just that, right? They're supporters of the community. You have a constituency, and you expect jurors to know better, okay? And in addition to that, there, of course, is going to be appellate arguments around whether the jury should have been sequestered, whether that venue was proper and appropriate. Look at the day and age in which we live. We live in a day and age where social media infiltrates everything we do, where there are cameras focused on everything we do. as was stated by the prosecution, the law suggests and otherwise presumes that jurors follow instructions. That judge has instructed this jury as to what those applicable instructions are. I'm letting you go home. You're not to be influenced by outside factors, Mike. You're not to talk about the case with anyone else. You're to base your decisions on the evidence. In the event lawyers make statements about the law, you are to be guided by what I tell you, not what they say. Closing arguments are not evidence, and so there are all these things that countermand what you might hear. Everyone has an opinion based on
manslaughter, right? And the judge will invariably instruct them to go back and use your best, whatever, I don't remember what the precise wording is, but do your best to come to a conclusion, to come to a unanimous verdict. They'll come back a day later or 2 days later saying, we can't find, or we can't come to a unanimous. That tends to be the sign that a mistrial may be coming on a charge, because they keep trying to instruct the court that they can't come to a conclusion, and the court keeps instructing them that, boy, you got to try and try to be unanimous one way or the other. It's certainly a possible outcome. Now, there are 3 different charges here, and the facts show them having encountered or engaged with Floyd aren't in dispute. The question is, did he cause the end of his life? The jury could possibly negotiate amongst themselves as to, well, we may not unanimously agree as to second-degree murder, but we could get everybody on board with manslaughter, and that happens, and that's certainly something. Now, you don't think there should be horse trading in the law, but what people do as a matter of, this is exactly what Shannon was talking about, with they pick a leader, and it's, to some extent, Lord of the Flies. They as a group have to set some social order and come to an agreement. So, yeah.
Sarah, as I say, you've been watching this as closely as anyone. What do we know about how the jurors have been acting, how much attention they've been paying throughout, about 3 weeks of this trial?
It's 3 weeks, and I don't know that people know what that pressure feels like as a juror, as you are being watched by the media and by the attorneys. You are under a spotlight, even though the public is not allowed to view you. There are a lot of people in the court who are paying attention to the jury. And, for the journalists in there, and I was in there for a day myself, when you watch how they engage, where they are writing notes, they are paying close attention. There was only a day where there was a little bit of fidgeting going on, but for the most part, they have really been engaging. When one of the medical experts that the prosecution brought in, Dr. Tobin, started talking about, feel your neck. Let me show you what happens when this is compressed. Let me show you where this is and that is. And he was saying, touch the back of your neck, touch the... Many of the jurors were doing so much so that the judge told them that, look, you can do this, but you are not required to do what this witness is telling you. So it tells you something about how much they're paying attention, how important this is to them to get it right. And we actually heard them say those very words when they were in voir dire. When they were questioned by the defense and the prosecution as they were picking jurors, many understood how important this case was. Some of them saying they wanted to be on this case because they knew its importance. They knew it was important to get this right and to pay close attention. And I think they have had a jury that has really paid close attention and been engaged the whole time.
Well, Shannon, if you're the prosecution, or the defense for that matter, what do you do while the jury deliberates? It could go on for hours, it could go on for days.
You sweat a lot, and if you're the defense, you're trying to keep your client calm, but you're also thinking and trying to anticipate what questions could come out, because when that note comes out, and I'm predicting we'll at least have a few notes, you're going to have to explain to the judge how you think the court should respond to that note. Sometimes you want to say, don't respond, well, it's an improper question. Other times, you're going to make suggestions as to what further guidance should be given, and the other side may disagree with you about that. So a lot of that time is spent anticipating what issues may come up. There may be some legal research you want to shore up about particular issues. That's what you are doing right now.
During the pandemic. A little bit of that wing season for us, some snow to the south, some cold weather elsewhere. Some warm weather in the future too, though. Tyler's first alert forecast explains just a second.
To be a...
Correct?
Yes.
You're doing that dance. You're doing that dance. You're doing that dance.
in these final moments before we can anticipate a verdict at some point. We talked to a lot of businesses in this area, especially in the Lake Street corridor. That was an area that was hit very hard. Many of them began boarding up weeks ago. They said they started putting together plans in preparation for this verdict. Well, now here we are on the standby. And some of the businesses did express to us that they were a bit unsatisfied with the leadership in this city, especially after, hundreds of millions of dollars in damage last year, $500 million with a B damage in this area. And some business owners did say they wished, the mayor had stopped by or some of the city leadership had visited them and asked them about all the destruction to their property. And, some of these businesses that lived through last summer's riots have just reopened their doors in recent weeks. Now, some say they're going to board up again. Others say they simply cannot afford to. Dana.
All right, Matt Finn, thank you. If you'll stick around, that would be helpful to us, and I'm sure you'll be very busy through the next few days. I want to play for you, again, everybody that's on the panel here, what the judge said in reaction to the defense bringing up the comments of Congresswoman Maxine Waters of California, who was in Minnesota.
The defense blamed everybody but Mr. Chauvin for George Floyd's death, including George Floyd, including the car that was next to George Floyd, including the emergency first responders who the defense suggested didn't act quickly enough, and the defense blamed the crowd. The problem is that the jury and the world met the crowd. We met the brave teenager who made the video. We met the firefighter who begged to help. We met Charles McMillan, the older gentleman who broke down on the stand because he could not save Mr. Floyd's life. And so when Eric Nelson, the defense attorney, talked about Mr. Chauvin threatening the crowd with mace, I don't think that helped his case. The prosecution pointed out that the crowd treated Mr. Floyd more responsibly than Chauvin did.
Chuck Rosenberg, the prosecution seemed to go out of their way to make clear that this was not a case against the police as a group, or even more than one officer, simply against the conduct of Derek Chauvin. Let me play some of that. We'll talk about it on the other side.
It may be hard for any of you to imagine a police officer doing something like this. Imagining a police officer committing a crime might be the most difficult thing you have to set aside, because that's just not the way we think of police officers. We trust the police. We trust the police to help us. We believe the police are going to respond to our call for help. We believe they're going to listen to us. This case is called the State of Minnesota versus Derek Chauvin. This case is not called the State of Minnesota versus the police. He betrayed the badge and everything it stood for. It's not how they're trained. It's not following the rules. This is not an anti-police prosecution. It's a pro-police prosecution.
He made those arguments today, but he showed that part of the case so meticulously in the earliest days by, I think the rep describes it as the crumbling of the blue wall. All the law enforcement testimony made that point for him. How heavily do you think that will weigh on the jury today, Chuck?
Nicole, I thought it was a very good argument. I found myself nodding my head when I first heard it. It is completely appropriate for us here in this venue to talk about the broader implications of the Chauvin trial and about police reform and about racism, institutional and otherwise. But what the prosecutor did in the case was narrow these fraught issues for the jury. He said, look, we are not considering police reform. We did not bring a case against the Minneapolis Police Department or any police department. You are here really to decide a much more narrow issue. Did this former officer, did this defendant murder George Floyd? If you look at all the evidence, consider it fairly, you listen to the testimony and you look at the exhibits, the answer is yes. So you, ladies and gentlemen, don't need to do other things. There's lots of things, and I think this was the implicit argument. that absolutely need to be fixed in our society and in policing and in the Minneapolis Police Department. Your point about other officers testifying, the blue wall crumbling, well, in my experience, good cops are disgusted by bad cops. They don't tolerate bad cops. They are disgusted by bad cops. But again, we narrow the issue in this case for the jury to apply the evidence adduced at trial to the elements of the crimes with which Chauvin is charged. And when the prosecutor did that, when he said, come with me, narrow your focus, look solely at this case for what this case is, he was doing exactly what he should be doing.
Shaq, do you have any reporting on, I know you get those pool notes about what a jury's doing during some of these moments. What does your reporting suggest today was like in the courtroom for the jurors?
Well, based on the reports that we saw earlier, it seemed as if the jury was as engaged as they were all throughout this trial. We saw early on that they were taking notes. Sometimes, in one pool report referenced jurors flipping back in pages at their notes and cross-referencing as the prosecutor, Steve Slisher, was going through and making his argument. There were other reports that as Eric Nelson's closing argument started to extend a little bit before that lunch break, as it crossed the 2-hour point, that some of the jurors started to become antsy, that they were kind of swiveling in the chairs a little bit, rubbing their eyes from time to time, and that's when you then saw the break from Judge Cahill interrupting those closing arguments. So, you know, it's always hard to read. All of the pool reporters always note the fact that all of the jurors have on the mask, so you can only really tell based on the eye and the expressions in their eyes. Other note to make is that for most of the trial, and that kind of changed in the final week, but for most of the trial, we didn't see any representative in the chair that's reserved for Derek Chauvin, the family representative. Well, much of last week that changed. There was a representative there, and today there was a representative there. We're not clear who the person was or what the relation is to Derek Chauvin, but there was someone there, and we also know that George Floyd's brother was representing the Floyd family in the courtroom today. The pool reporter at one point noted that he just had his hands clasped and his head looking down at his hands as the testimony and as some of that video was playing in court. So it's, you know, that tight courtroom that we're seeing, you know, we're reading kind of a lot of tea leaves and you're getting some assumptions in these pool reports, but the bottom line that you see, and is consistent throughout the trial, is that this is a very engaged jury. They're always taking notes. Every once in a while they get a little antsy, but they're paying attention and they're taking their job seriously, at least based on the perception of their actions.
Shaq, do we know if they will be allowed to go as many hours as they want to today and in the coming days, or do they have set time limits? Has the judge said you have X amount of hours today if you haven't reached a decision? You know, do we know what parameters have been put on how much time and when they spend it deliberating?
We're not exactly clear on that. We know that each day we will get a notification when they start deliberating. And that's what we got today. That's how I was able to tell you that they started deliberating at 4 p.m. Central Time. We know we'll get a notification when they stop deliberating, and we know we'll get a notification when there is a verdict. How long they go, I am not particularly sure of that, especially because this is unlike other juries in the sense that they are sequestered. So they may have more flexibility than a standard jury. Nicole, if I can make one quick point that you were making in terms of the policing.
Please.
And how the prosecution made that a central part of their closing argument, that this is not about policing being on trial. He called it a very noble profession at one point. I will say, if you talk to protesters, if you talk to demonstrators, you may hear some in the background here, this trial is very much about policing for them. They want a conviction here because they believe this will send a message about police accountability, that it will set a limit of what can happen, what police can get away with in their minds. So outside of the court, for people who have been advocating, people who were protesting Dante Wright shooting, people who in Chicago are still protesting the death of Adam Toledo, this case very much is about policing, and they want policing to be in focus. Use of force guidelines, they want that to be in focus. It's very clear why the prosecution wanted to separate that, especially when we knew members of the jury, they say they saw police as, that they trusted police and felt safe with police. But for people watching, for people out here on the streets protesting and who have been protesting since about a year ago when George Floyd was killed, this is very much about policing.
Well, and it speaks, Paul Butler, to the two realities. I mean, I think it's clear that there is a reality, and this is what Derek Chauvin has a right to, a jury that is sequestered, and these issues being narrowed, as I think Chuck perfectly articulated, and Chuck added to our understanding of that. But this happens at this moment where, since Derek Chauvin has been on trial 10 miles away, Daunte Wright was killed by police on the phone with his mother when he was pulled over and shot and killed. I mean, the rest of us who are sitting on the jury cannot separate this moment and what the country is right now and the reality that is life in America for black men.
That's right. So the prosecution emphasized that the name of this case is State versus Chauvin. It's not state versus policing. It's not about the national reckoning on race. And Nicole, the prosecution is making that emphasis for a key strategic reason. There are jurors who support the police. We know from the questionnaire that they all had to fill out. And the prosecution wants to send a message to those jurors that you can still vote to convict Chauvin. That does not mean that you don't support the police. The prosecutor told the jurors nothing is worse for a good cop than a bad cop. At the same time, as this trial has been going on, we've seen other instances of black people, Latinx people who have been killed or beat up by police officers. And of course, for the country, it's hard to keep those two things separate. I would note that this is ultimately a case about a bad apple cop, if you believe the prosecution. Some of the other issues that emerged last week were at least 2 African-American men were beat up or killed after traffic stops. It goes to more systemic issues in policing, things that are more about anti-black bias that's embedded in the system that allow the police to have the kind of power they do over people when they make traffic stops. And so one case about a bad apple cop, other cases more recently make us focus more on ongoing problems of systemic discrimination in the criminal legal system.
Eddie, there's some incredible reporting over the weekend in the New York Times about all of the incidents of police violence just since the Derek Chauvin murder trial has been ongoing. My colleague Jonathan Capehart wrote a powerful piece, said simply that being black in America is exhausting, and I was struck by all of the powerful people who quoted it.
During the defense close was this concession about when George Floyd's last breath occurred. Now, by doing so, they've now essentially admitted that there's this 3-minute period of time that Derek Chauvin remains on George Floyd, and you heard the prosecutor hit on that in the rebuttal. So all of these issues percolating with the jury, and look, simple. Sometimes the simplest answer is the answer. That's what the prosecution's hoping the takeaway is.
No, little teaser coming up in the next hour. We'll let everybody hear that Eric Nelson said was the biggest moment in the case, and he'll make his explanation, but it was 8/25/16. He does make the admission that George Floyd breathes his last breath. Darren Porcher, you and I have talked about the video. Personally, I thought we'd see more video, the body cam footage from the prosecutors. You think that was a miss there, that they didn't go to it more often?
I think the prosecutors were trying to be careful in their approach, because when we look at what Eric Nelson did, he introduced a lot of that video and he paired it off with the procedural guidelines. But as I mentioned earlier, the void was he didn't introduce the necessary force, meaning the reasonableness that should be attached to the use of force, whereas once it becomes excessive, that's when you need to stop. And that's something that I think Eric Nelson was very specific in not adding into the equation. But going back to what you mentioned in terms of the video that was being brought forth by the prosecution, I think that this was intentional on their part. It wasn't forgetful.
Interesting. All right, coming up, we mentioned it. We're going to let you listen to that moment that Eric Nelson said is the biggest moment in the case. Does it work in his favor or not? You're watching HLN's continuing coverage of the Derek Chauvin trial. We are now in verdict watch. Stay with us.
With communities being terrorized by folk who had the legal authority to use deadly force. I know it's a case, but it bears the burden of the contradictions that define the country in this moment, Nicole.
And Shaq, you've been on the ground for us there since the earliest days. You've spent hours, I'm sure by now, of time covering Minneapolis in the aftermath and bringing all the people who have gone out to the streets in the midst of a pandemic to protest. And I wonder if you can just pull that thread from the earliest days to what you're seeing today.
Well, really, I think, when we talk about Minnesota being on alert, when we talk about the city of Minneapolis and the surrounding areas being that tension that we have, I think this is the continuation of it. This is why there's that tension. And for example, a group that you see probably walking behind me now, they're heading to a protest down the street. That's the sense that you're getting, that this is only picking up. People are only going to be watching this incredibly more closely. The part that I keep going back to is that this is only one trial. We still have 3 other officers that are involved in this situation that have a trial scheduled for August. So while this may be the start of it and people are tense about what they can expect from this, there's a lot of other steps that they'll be paying attention to as well.
Okay, Shaq referenced a protest starting to grow down the street. We're going to go there. Our colleague, NBC's Megan Fitzgerald, is with those protesters outside the courthouse in Minneapolis. Megan?
Yeah, hey, Nicole, we're starting to see protests all throughout the area here starting to grow, but specifically behind me here, this is very interesting. This group here that's getting ready to disperse, this is a group called Principals for Good Trouble. Now, who we are seeing here are principals and assistant principals from all across the Twin Cities. They formed this group about a couple months ago, over the summertime, shortly after George Floyd died. And they said the reason why they did this is because they feel, as educators, they have a role to play in educating the younger generation to try and break down stereotypes, break down biases, educate students about the history and how we potentially got to this place. So at this moment now, they tell us that they are actively teaching students about the trial and what's going on. There's concerted efforts to try and make sure that Black and brown students within their schools feel like they belong, that their lives are valued. And so these teachers are out here. They've been speaking to one another. They'll be joining protesters later on tonight. But again, I mean, this is quite an interesting piece of speaking to protesters, because this is actively what some people are doing to try and make a difference within their own community, Nicole.
You know, Eddie, it makes me want to cry listening to Megan's coverage. I mean, if you have, this has been a challenging, I think, kind of crisis for the country to explain to small kids. And I'm sure that the conversations that I have to have pale in comparison to the conversations that Black parents have to have with their kids. I mean, just your thoughts on that report from Megan, Eddie.
Oh, it's amazing. You know, I mean, people are reaching for a different way of being together. And Nicole, let me just say, the conversations you're having with your kid are really critical, right? Because there's nothing I could tell my son. If a police officer has made up his mind or her mind to take his life or to be threatened by him, there's nothing I could tell him that could save him. Nothing he could do that could save him. We're in a moment of transition. John Dewey wrote a book in 1927 called Public and Its Problems. And he's talking about the eclipse of one way of life as another one is imagining, trying to come into existence. We have old languages and the like. We're in that moment of transition, Nicole, and we're going to have to figure out how to be together different. But this is a powerful moment. Principles, my goodness.
We're We're all going to do it together. You always manage to crack me open right when they're screaming rap and time to hand it off. So I could have listened to you for another hour. I want to thank Megan Fitzgerald, Shaq Brewster.
The security looks like on the ground. Closing arguments in the case given today. But it also comes as one Democratic lawmaker traveled to Minnesota.
Mr. Merkley, aye.
It comes to that. And then, of course, all of this is happening as each side in this trial makes their final pitch to the jurors right before they begin those deliberations.
His name was George Perry Floyd Jr.
The first words in closing arguments for the prosecution were not of the man on trial, but of the man they want jurors to remember.
This case is exactly what you thought when you saw it first. When you saw that video, it is exactly that. You can believe your eyes.
The prosecution arguing it was Derek Chauvin's knee to the neck that eventually killed Floyd. Chauvin is facing second-degree murder and manslaughter charges, along with third-degree murder, the most serious of which carries a penalty of up to 40 years in prison. And the prosecution took jurors back through witness testimony with diagrams and charts, reminding them of why they say Chauvin is guilty of it all, and why he had every opportunity to stop what happened that day.
He knew better. He didn't do better.
Making clear, this trial was not about the Minneapolis Police Department, but about one former Minneapolis police officer.
This is not an anti-police prosecution. It's a pro-police prosecution.
The defense began on the topic of what a reasonable officer would have done, considering the totality of the circumstances, including the violence of the initial struggles.
The 9 minutes and 29 seconds ignores the previous 16 minutes and 59 seconds. It completely disregards it. It says, in that moment, at that point, nothing else that happened before should be taken into consideration by a reasonable police officer.
Then, largely sticking to their themes, that George Floyd died from drug use and his medical history, that Chauvin did exactly what he was trained to do, and the perceived threat of a growing crowd distracted Chauvin.
In the precise moment the force was used, demonstrates that this was an authorized use of force, as unattractive as it may be.
Prosecutors pushing back in their opportunity for rebuttal.
When Mr. Floyd is saying, please, please, I can't breathe, 27 times in just a few minutes, you saw it when Mr. Chauvin did not let up and we didn't get up. When he knows he doesn't have a pulse, he doesn't let up or get up. Even when the ambulance comes, he doesn't let up or get up even then.
Each side hoping to leave a dozen jurors with a final impression before they deliberate on one of the most consequential cases in Minnesota history as the world watches.
There is absolutely no evidence that Officer Chauvin intentionally, purposefully applied unlawful force. This was a policing. This was murder.
Outside the courtroom, a city and country braces for reaction to the verdict when it comes, with many cities on higher alert, while Minneapolis has added more fortifications outside police precincts, and the Minnesota governor is now requesting law enforcement resources from Ohio and Nebraska in advance of a verdict. While back inside the courtroom, once jurors had begun deliberations, the judge expressed frustration at Congresswoman Maxine Waters for telling protesters to stay in the streets if the verdict is anything but guilty.
I wish elected officials would stop talking about this case, especially in a manner that is disrespectful to the rule of law and to the judicial branch and our function. I think if they want to give their opinions, they should do so in a respectful and in a manner that is consistent with their oath to the Constitution.
Now, significant
2021, that is coming up in your Money Matters at 10. Well, with more events, more people will be traveling, but a crunch in the rental car market could have you paying more for a rental or find it more difficult to get one for an upcoming vacation.
For a mistrial that was brought forward by the defense. We're also expecting an update from law enforcement and more details on the governor's request to bring in additional law enforcement to assist in the response to protests. And then finally, we should mention and note that all of this is in preparation for a verdict, but until we get there, Wolf, all we can do is wait.
So that's what we certainly will be doing. Omar, thank you very much. Joining us now.
Lasts a lifetime.
Children and infants. This is the first time something like this is being offered in the Midwest. The Pledge study was launched through a grant from the Helmsley Charitable Trust.
This program is essentially screening every child in our footprint, ages 2 and 5, for the presence of something in their bloodstream.
Human rights situation in Belarus. I commend the Biden decision.
And we came together bipartisanly, and we passed a small package of reforms, a beginning. But we stalled. We weren't able to pass a package to fund and rebuild those businesses, to make sure that we provided those opportunities in those very communities that were traumatized. We all know that what you're seeing right now is reactive. It's not proactive. Communities have been demanding change. They've demanded that it wasn't enough. And they very clearly stated if the systemic changes that need to be made aren't made, then things would repeat themselves. And when I say things, I mean the horrific deaths of young black men over and over, and a systemic feeling in this state that not everyone gets the same opportunities. And just a week ago on Sunday afternoon, we in the world watched again as Dante Wright's humanity was taken from him, and then his life. And now we're here with our justice system. Just put the decision for Derek Chauvin will be decided by that jury. His fate will be decided by the jury. We'll decide our fate in this state. We must acknowledge two truths. We cannot allow civil unrest to descend into chaos. We must protect life and property. But we also must understand very clearly, if we don't listen to those communities in pain and those people on the streets, many of whom were arrested for speaking a fundamental truth, that we must change or we will be right back here again.
George Floyd's final words on May 25, 2020 were, "Please, I can't breathe." And he said those words to Mr. Officer. He said those words to the defendant. He asked for help with his very last breath. But Mr. Officer did not help. The defendant did not help. He stayed on top of him, continued to push him down, to grind his knees, to twist his hands and twist his fingers into the handcuffs that bound him.
David, as we await a verdict on 3 separate offenses, walk us through what the prosecution was doing there. Obviously, it can apply to more than one thing, but it seems certainly to legally apply to the argument that this was actions taken with a depraved mind. If someone is clearly and even desperately telling you what they're going through.
Absolutely, Ari. I think that's correct. They are keying in on the elements that they have to prove for those individual offenses, including third-degree murder, depraved mind. What they're also trying to do is something that it's easy to overlook. We tend to think of closing argument as argument, and they're actually not, at least not for people who spend a lot of time studying them. You're trying to do more than just marshal all the evidence you presented to the jury. What you're also trying to do is equip the jurors who are in your favor to go in that room and fight for you during deliberations. I think that's an issue here where you've got 3 separate charges and you'd prefer to see them convict on the more serious charge. Moments like that, where someone whose job is to protect and to serve doesn't show even an ounce of humanity that might have saved someone's life, is a type of message jurors will remember when they're back there in deliberations.
There's lots of what-ifs that could have happened, what could have happened, what should have happened. Lots of them in lots of regards. We have to analyze this case from the perspective of a reasonable police officer at the precise moment with the totality of the circumstances when it comes to the use of force. We have to look at the cause of death to determine, did Mr. Floyd die exclusively of asphyxia, or were there other contributing factors that were not the natural result of Mr. Chauvin's acts? Things that happened that were set in motion before Mr. Chauvin ever arrived. The drug ingestion, right? The bad heart, the diseased heart. hypertension. All of these things existed before Mr. Chauvin arrived. The struggle, what role did the struggle play? We know, based on a prior incident, that Mr. Floyd's heart was beating at 219 over 160 in a situation where he was confronted by police and had ingested drugs. He didn't die that day. All of this, ladies and gentlemen, all of this, when you take into consideration the presumption of innocence and proof beyond a reasonable doubt, I would submit to you that it is nonsense to suggest none of these other factors had any role. That is not reasonable. And when you, as members of the jury, conclude your analysis of the evidence, when you review the entirety of the evidence, when you review the law as written, and you conclude it all within a thorough, honest analysis, the state has failed to prove its case beyond a reasonable doubt. And therefore...
And then they will die on out of here, and we'll see a brighter day and a drier day on Wednesday. All right, here's your forecast for tonight. We'll see partly cloudy skies in the south, a bit of clearing to the north. Our lows tonight in the teens, upper teens to the low 20s. It is going to be chilly.
Defensible, which is what I think we saw with the criminal defense side here. But at the end of the day, Wolf, he threw everything he had against the wall, from carbon monoxide to it wasn't his fault, to the crowd, to everything he possibly had, trying to find one juror to hang their hat on something other than murder. And we'll see what happens.
And on that point, Paul, with Chauvin's defense attorney, Eric Nelson, he went on for maybe 3 hours, if not more. Was he able to sum up his closing argument and potentially create some reasonable doubt in that closing argument?
You know, he started out very slow in this trial. He kind of bumbled around at the beginning of the trial, but always he would kind of get to a good point in his cross-examinations, and I was expecting a really weak performance. I found it, unlike my friend Vcr, I found it to be a relatively strong performance for an attorney who has a very difficult case. And what he did was he kind of shifted the focus of the case by saying, listen, look at the entire totality of the circumstances. And as he went through the whole case, not just the last 9.5 minutes, he would then take out the book of regulations as to what the Minneapolis Police Department requires of its officers. And he would juxtapose that on the screen against what really happened and said, all of these things were authorized by the code book in Minneapolis. And then finally, when he reached that last 9.5 minutes, and more particularly maybe the last 3 minutes of the tape, he had by that time put on the record the fact that Floyd was out of control when they tried to put him into the police van, that he was saying, I can't breathe, even when he was on his feet when he was first apprehended, and that was meant to suggest that later on Chauvin didn't have to believe that when it came up again. That's what Nelson was really saying to the jury when he was saying, look at the whole totality of the circumstances. But I think
you'll hear from my the help on Dakota News Now at 6.
Closed captioning sponsored online at Lifescape S.
We will! We can go! We can go!
I know!
Your question here on Capitol Hill that lawmakers, certainly in the Democratic caucus, are being asked about. You know, Pelosi was caught up by some reporters in the hall. She was asked that. I had asked her office, other Democratic leaders' offices, about what about Waters' remarks, and got no response. This is something that Democratic leaders don't want to touch. And what happens with Kevin
Cmgus regime, and we stand with the Belarusian people and their peaceful fight for democracy.
have a
straight up or down vote on censure or whether they move to table and move this off the floor, Brett.
Yeah, it's fascinating. Obviously, no matter what happens with the Democrats, the judge in this case said that it may have given the defense enough of an appeal item to overturn the case. That's from the judge in the Chauvin case. Chad Pergram live on Capitol Hill. Some more news out of Capitol Hill. Capitol Police Officer Brian Sicknick, who died after he confronted protesters during the January 6th riot, died of natural causes. That's according to the D.C. Medical Examiner, who says Sicknick suffered a stroke. The determination means the officer's death was not brought on by an injury. Last month, 2 men were charged with assaulting the officer with chemical spray during that riot. I want to bring you news from around the world. Also breaking tonight, foreign policy challenges for the new president. The Biden administration facing pressure on a number of fronts. Russia's continued military buildup near its border with Ukraine. China's increasing intimidation of Taiwan. And negotiations over the Iran nuclear deal amid Iran's increasing enrichment of nuclear material, thumbing its nose essentially at the U.S.
And the tiny little moments that just knock you off.
In 16 seconds, he admits George Floyd breathed his last. And at that point, he says, keep your eye on the video. So we're going to watch some body cam video, let Eric Nelson make his point, and then we'll get our expert panel take coming out.
If you recall from Dr. Tobin's testimony, nobody disagreed that Mr. Floyd took his last breath at 8:25:16. 8:25:16. What is happening at the very precise moment that Mr. Floyd takes his last breath? You're taking one piece of evidence and you're comparing it against the rest. This moment, 8:25:16, as Mr. Floyd is taking his last breath.
Get off him now! What the fuck? He got made. He got made. He cannot find that one. Get up here. No, first of all. Look at him.
3 things happen. Mr. Floyd takes his last breath. You see Officer Chauvin's reaction to the crowd is to pull his mace and shake it. He's threatening the use of force as is permitted by the Minneapolis Police Department policy. And Genevieve Hanson walks in at that time from behind him, startling him. All of these facts and circumstances simultaneously occur at a critical moment.
There's Eric Nelson making his point at the critical moment. George Floyd breathes his last, and then you hear in the video, it gets a little loud. So Darren Porcher, it's back to that crowd. They're threatening, they're distracting, right?
Right. It goes back to the threat assessment that we spoke to earlier. It was okay for former Officer Chauvin to introduce or display his mace or pepper spray is what I believe he had. But once you saw that the threat assessment came down a notch and there wasn't an apparent threat in front of you, that's when you recede back to no need to apply a level of force. And then he goes back to just continuously keeping his knee on George Floyd's neck. So that's somewhat problematic in that on one instance, he recedes on the use of force, but in that same instance, simultaneously, he continues to keep his knee on George Floyd's neck, who clearly didn't present a threat. We all saw in the video, George Floyd was not resisting. George Floyd was literally running. He breathed his last breath, as you mentioned, but at the same token, he continued to keep his knee on his neck. That's where the problem comes into play in connection with the use of force that was employed by former Officer Chauvin on George Floyd's neck as a result.
Yeah, and Ariva, you hear that? That's a point that could backfire, right? As that jury stops and says, wait a minute. If he's breathing his last, doesn't he need help? Why are you worried about a crowd?
Not only doesn't he need help and should I be providing help consistent with the training that I've been provided, that I call EMS and I give the suspect under my custody and care, CPR. He didn't do that, we know that. And Jerry Blackwell made a good point, you know, it's your custody, your care, not your custody, I don't care. But more importantly to me, I'm looking at him grabbing for his mace thinking this guy is so out of control. He has Mr. Floyd under his knee. He's continuing to apply pressure to Mr. Floyd. Now he's about to pepper spray or use mace against these, you know, very innocent bystanders. And again, if these bystanders, and Mr. Blackwell made this point, are so menacing, you have a radio, you have a gun, you have bullets, you have you know, you have the power of that badge. Why isn't there conversation with Tao about calling in for backup or doing something else with this quote-unquote, you know, rowdy and menacing crowd? So I just think the argument about the crowd falls completely flat, and showing that video of him going for that pepper spray, to me, just plays into the argument we heard from the first prosecutor, which is, we hadn't heard this before, Mike. What was going on in you know, Chauvin's mind, and what the prosecutor, you know, gave us the inference is that it was his ego and his arrogance, that he was not going to allow that crowd to push him around. Eric Nelson tried to say, well, you know, they're being videotaped, so who would do something wrong on videotape? The reality is lots of police officers we've seen do things that are unlawful on videotape, and quite frankly, it's because many of them have not been held accountable. So this sense that because they're being videotaped, they're not going to, you know, violate the law or violate their policy, it's just not consistent with what we see happening on a daily basis. So that videotape to me just shows this guy is out of control, he's callous, and he's ready to use even more force against a 9-year-old, 61-year-old, and 2 high school juniors.
Misty, what do you think he was going for there? And again, to Ariva's point, we heard the prosecutor say that. Who's this crowd? A 9-year-old, teenagers, a 61-year-old man. What's he going for there? Is he hoping that because the volume raises, that a jury member will think, whoa, that does sound threatening? Is that the hope for him?
Yeah, this is the big bag crowd theory, Mike, and you're using it to explain 2 things. The act of keeping his knee on George Floyd, as well as the omission, his failure to provide CPR, saying that, well, look, we've got to take this crowd into consideration. Oh, look, Derek Chauvin pulls out his mace right at that moment, that there's somebody coming from behind, Genevieve Hansen, establishing that, oh, look, somebody can come from any direction. Again, it all goes back to, we got to look at this as the totality of the circumstances. This is what the defense is going for. They're saying it's not that simple. There's all these issues that need to be taken into consideration. Something Eric Nelson did well, he used points from prosecution witnesses, specifically Mercel as well as Jody Steiger, to establish his point with respect to the fact that the crowd is a consideration a police officer does take into account. So that's what they're going for. Whether or not the jury buys it, only time will tell.
Vinu, are you tracking with Eric Nelson on that point at 8:25:16 that the crowd level, the volume of the crowd is raising, so hence they're now a distraction?
I think this is the problem with Nelson and his whole demeanor and manner throughout the course of the trial. He's raised some good points, but he doesn't know how to argue them. This was a time where you've got to be strong, and you've got to say and paint this picture in a manner that really lets the jury feel what Chauvin was feeling. And he failed to do that. When he starts saying things like, well, I'm not saying the paramedics should have done this or should have done that. What he should have done is laid out in his PowerPoint, laid out all these intervening factors, the lack of medical attention, the fact that they took all the stuff, and don't apologize. He kept apologizing. This is something that Nelson, and unfortunately the majority of people in this country don't understand, is that there is no presumption of innocence. Chauvin is not presumed innocent, he's presumed guilty, as are almost all criminal defendants. Therefore, Nelson, especially in a trial like this, has to, practically speaking, prove his innocence. While he can argue that the burden is on the state and continue to argue that, he needed to be stronger. Look, he could have vaccinated the jury, and I've said this a few times already. He didn't prepare the jury for the prosecutor's rebuttal summation, right? So when the prosecutor's rebuttal summation, Blackwell says, this is so simple that a 9-year-old understand it. Really, prosecutor? That was that simple? Why did you have 5 million witnesses? Why did you call 2,000 experts? Obviously, I'm exaggerating, but that's what it really was like. When you look at this, that's the thing that, now Nelson, that's Nelson's fault. By saying, look, when I sit down, Blackwell's going to get up and say, look, this is a simple case, use your common sense. Of course he's going to argue common sense. I saw that coming from a mile away. What he could have said was, look, your common sense, what he's really Blackwell is going to tell you is ignore logic. Ignore the reality of the situation that tells you, they're telling you that his drug use, his heart condition, his COVID, all this stuff, none of that was a factor? Come on, folks, use your common sense.
To get worse. Call today.
To be identified as perhaps potentially criminals or something like that. But that was quite a traumatic experience. In Minneapolis, I've had randomly, been stopped because officers said I, took the cart out of the store and took it back in the store and got back in my car, and he was somehow concerned that maybe that meant I was dealing drugs. I've had officer almost throw me off my bike, just coming back from biking down the parkway, and saying that someone called and said they saw their neighbor's back door open and saw me riding down the sidewalk down the street, and thought maybe for some reason I had burglarized their neighbor's home, which of course was not possible because I was wearing shorts and a t-shirt. So this happens all the time, here in Minnesota, and I believe it happens all over the country. This is real. It's time for a reckoning. It's time for us as a country to come together and once and for all resolve this problem. I'm very disappointed that even after killing of George Floyd, our state legislature did not pass meaningful reform. I'm very disappointed about that. And until we do, these problems are going to continue to happen. We need real reform, and we need it now.
Yeah, and you're absolutely right. It's not just Minnesota, but it's all over the country. I hear this from my black friends, black men who have grown up here in the United States, many of them very, very successful, and you're the mayor of this city, but they tell very similar stories that you tell, that they were simply stopped because they might have been driving a nice car and some police officer didn't like the way that looked, if you will, and it was a tense situation. What do we need to do, Mayor? First of all, in your community, how do we fix this?
First thing we all have to do, Wolf, is we all have to commit to working together to resolve this. We have to pass policies on the local level, on the regional and state levels, and of course, the bill that's currently pending in the U.S. Congress, that is the George Floyd Act. That bill needs to be passed. It needs to be passed now. There's meaningful legislation in the state legislature here in Minnesota that has passed the House, but it needs to pass the Senate. That needs to be done now. On the local levels, we're taking certain steps. The city of Minneapolis just a couple days ago voted to remove traffic enforcement from the police department, from armed police to a more of a civilian unit. So there are tangible steps that we can take. My city is going to be looking at implementing some of those reforms, and they are reforms that work. The research has shown that they work, and we just have to really move away from thinking about policing and thinking about public safety and public health, because I believe that if we focus that as our priority, then we're going to be open to more of the sort of innovative changes that need to happen in order for us to transform the state of public safety in our communities. It needs to happen now. There's no reason that we should be waiting, and in doing so, we need to make sure that we're treating protesters in a humane way as well.
I understand, Mayor.
That point, any chance for snow is going to be immediately confined to the nighttime, assuming we even get to that point. The long-range outlook for temperatures does skew above average, so the deck may be stacked against a last-second wintry hurrah. For KELO and weather, I'm meteorologist Adam Rudd.
Another very cool day tomorrow, partly to mostly cloudy, a few light showers possible during the afternoon.
Thanks for joining us.
See you later.
Tonight.
Tonight, Derek Chauvin's fate is in the hands of the jury as the city and the nation anxiously await a verdict. Barricades, boarded up businesses, and 3,000 National Guard troops on duty in Minnesota as the prosecution and defense deliver their closing arguments.
The reason George Floyd is dead is because Mr. Chauvin's heart was too small.
The state has failed to meet its burden of proof beyond a reasonable doubt.
Now, the jury deliberates. The race to vaccinate. All Americans 16 and older are now eligible to get a vaccine in all 50 states. So why are vaccinations down in some places? Missed warning sign. The gunman in Indiana's FedEx massacre able to buy new weapons after police seized his gun. Treadmill safety. Disturbing video of a 2-year-old boy dragged by a Peloton Tread Plus, miraculously walking away. The government warning tonight. Eye on Earth. Texas leads the country in green energy construction. How the Lone Star State is training oil riggers to build wind turbines. Remembering Hester Ford, the longest living American, the 116-year-old's secret to a long life. And taking flight on Mars as a NASA helicopter becomes the first to fly on another planet, the woman behind this historic project.
This is the CBS Evening News with Nora O'Donnell, reporting from the nation's capital.
Good evening, and thank you for joining us. We are going to begin tonight with breaking news. One of the most high-profile murder trials in American history is now with the jury. After nearly 3 weeks of testimony, 12 jurors will now decide whether former Minneapolis police officer Derek Chauvin is guilty of 2 counts of murder and 1 count of manslaughter in the death of George Floyd. In dramatic and dueling presentations today, prosecutors and defense lawyers made their closing arguments. Prosecutors saying Officer Chauvin knew better, he just didn't do better when he used his knee to pin 46-year-old Floyd to the ground, saying this wasn't policing, this was murder. But Chauvin's lawyers argued the former officer was following his police training and that there was no evidence his client intentionally applied unlawful force. What this jury decides will no doubt send shockwaves through Minneapolis and across the country, with police and the National Guard called up in major cities and businesses boarding up expecting widespread protests. Our correspondents are standing by in Minneapolis, and CBS's Jamie SIOUX is going to lead off our coverage from outside the courthouse. Good evening, Jamie.
Good evening, Nora. After a marathon day of closing arguments, the jury is now sequestered and will be until they reach a unanimous decision on each of the 3 charges that range from murder to manslaughter. It's incredibly rare for a police officer to be convicted. Recent data shows it only happens in about a third of cases.
This wasn't policing. This was murder.
The prosecution making its final plea to the jurors, telling them why former police officer Derek Chauvin should be found guilty of murder.
This was not an accident. He did not trip and fall and find himself upon George Floyd's knee and neck. He did what he did on purpose.
Prosecutor Steve Slisher began closing arguments by talking about the life of George Floyd. He then described in disturbing details how that life ended.
The defendant stayed on top of him for 9 minutes and 29 seconds. So desperate to breathe, he pushed with his face to open his chest, to give his lungs room to breathe.
The prosecution played police body cam video. Floyd said, "I can't breathe," 27 times. They were his final words.
George Floyd begged until he could speak no more, and the defendant continued this assault beyond the point that he had a pulse.
Slisher pointed to 7 expert witnesses, most of them fellow officers, all testifying that Chauvin used unreasonable force.
Believe your eyes. What you saw happen, happened.
He dismissed the defense's theory that Floyd died of a heart attack, drug overdose, or carbon monoxide poisoning.
I submit to you that the state has failed to meet its burden of proof beyond a reasonable doubt.
Defense attorney Eric Nelson argued that jurors need to examine what happened before the 9 minutes and 29 seconds. He said Chauvin did what any reasonable officer would after seeing Floyd struggle with other officers.
The amount of force that was being used by officers King and Lane was insufficient to overpower Mr. Floyd's resistance to getting into the car.
He played video showing how the struggle continued when Chauvin got involved. Nelson also argued that Floyd's heart disease, as long as his use of fentanyl and methamphetamine, significantly contributed to his death. He even cited the county medical examiner's findings.
So Dr. Baker's conclusions that Mr. Floyd's arteriosclerotic and hypertensive disease played a role in the death.
During rebuttal, prosecutor Jerry Blackwell talked about the 46th witness, common sense.
You were told that Mr. Floyd died because his heart was too big. The reason George Floyd is dead is because Mr. Chauvin's heart was too small.
And Jamie joins us now. And Jamie, something...
Final moment does not tell the whole story.
A reasonable police officer would, in fact, take into consideration the previous 16 minutes and 59 seconds. The experience with the subject, the struggle that they had.
He showed video of Floyd resisting in the police vehicle.
Mr. Floyd was able to overcome the efforts of 3 police officers while handcuffed.
And he argued the bystanders seemed like a threat.
A reasonable police officer is recognizing that the crowd is in crisis. So a reasonable police officer considers his department's training. What are these potential signs of aggression that I may be confronted with?
The defense also arguing drugs and heart disease led to Floyd's death.
The failure of the state's experts to acknowledge any possibility at all, that any of these other factors in any way contributed to Mr. Floyd's death defies medical science, and it defies common sense and reason.
The prosecution challenging that point in rebuttal, arguing even if Floyd's drug use and heart condition contributed to Floyd's death, what matters is that Derek Chauvin's actions caused his death. Prosecutor Jerry Blackwell recalling the testimony of the 9-year-old girl who took the witness stand.
The fact that it's so simple that a child could understand it. In fact, a child did understand it when the 9-year-old girl said, "Get off of him." That's how simple it was. Get off of him.
Alex Perez joined us now from Minneapolis. And Alex, the case is now in the jury's hands tonight. The judge instructing them not to let bias, prejudice, passion, sympathy, or public opinion influence their decision, and warning them not to consider what consequences their verdict might have. These jurors likely know that the country is watching.
Yeah, David, the judge very slowly and carefully explaining all of those instructions to the jury. Beginning tonight, they will be sequestered during deliberations. They'll work each evening until about 7:30. They've also been given laptops with all of that video and other evidence that they saw in court. David?
Alex Perez leading us off from Minneapolis. Alex, thank you. I want to bring in ABC's chief legal analyst, Dan Abrams, tonight, watching the proceedings with us all day. And Dan, I know the prosecution will have a personal narrative in their closing argument, essentially arguing that Derek Chauvin had 9 minutes, 29 seconds, essentially to change course, and that even after Floyd stopped breathing, Chauvin did not stop. They said even after paramedics arrived, Chauvin did not stop with his knee to Floyd's neck.
Yeah, they're making the point this was not a split-second decision here. And they did keep emphasizing again and again, believe your eyes. Use your common sense. And then they would intersperse with that the expert testimony using these big graphics to say they all say the same thing, which is that the force was not reasonable and that Derek Chauvin's actions were a substantial cause of the death.
On the other side, Dan, the defense asking jurors to think about what came before those 9 minutes, that they must take everything Chauvin witnessed that day into account, and that they must consider other potential contributing factors in George Floyd's death.
Yeah, they try and push the timeline back 17 minutes. They say you have to understand what was going on in Derek Chauvin's mind, what he had already seen from George Floyd, to understand why he did what he did. And they also oppose the possibility of a whole series of other causes of death. Remember, as a legal matter, all prosecutors have to prove is that Derek Chauvin's actions were a substantial cause of death, not the only cause.
Dan Abrams watching the trial with us today. Dan, thank you. And we will, of course, stay on this as the jury deliberates, and we will break into programming when there is a verdict. Thank you, Dan.
We're going to turn in the meantime to the other news this Monday night, the coronavirus here in the U.S. Half of all adults have now had one shot of the vaccine, and everyone 16 and older is now eligible here in the U.S. In New Jersey today, teenagers getting vaccinated, 16 and 17-year-olds. You see the numbers right there. 130,995,000 people have now had one shot. And tonight here, what the CDC is now saying about the temporary pause of the Johnson & Johnson vaccine. The CDC director is saying they are looking into a small number of additional cases that might be related, though she said not confirmed. Here's ABC's Stephanie Ramos tonight.
Tonight, a green light for every American 16 years old and older to get a vaccine, a moment millions have been waiting for.
Finally feel like I can go out with COVID and feel safer.
I feel like it's just like the end to this whole crazy past year, and so I was really excited at the first opportunity to get it.
The country hitting a new vaccine milestone. More than 50% of adults have gotten at least one dose.
I feel great. I feel like a weight off my shoulders.
But COVID cases are still hovering around 67,000 a day. Another challenge, there are more people unwilling to get the vaccine in counties with the highest COVID rates.
Thanks to a small drone-like helicopter. Scientists at NASA's Jet Propulsion Laboratory celebrating the short but significant flight earlier today. Dan Sheneman has a look for us.
That Ingenuity has performed its first flight.
History was made early Monday morning as a first-of-its-kind helicopter launched over the red planet's surface for a memorable 40-second flight.
Don't think I can ever stop watching it over and over again.
These stunning images were captured by rover Perseverance. The 19-inch, 4-pound chopper known as Ingenuity lifted off the Martian surface, hovered roughly 10 feet before settling back down.
Over the next coming days, we have up to 4 flights planned, and increasingly difficult flights, challenging flights.
NASA calls the historic flight a Wright brothers moment.
And we'll build on Ingenuity's success to see how we can deploy this capability on future Mars missions.
This event marks the first controlled powered flight on another planet other than Earth.
So the air is very thin, and Ingenuity had to be really light, small, and has to be able to fly in the thin atmosphere and survive on its own. It did all of that under 4 pounds.
To help combat the elements, Ingenuity was equipped with 4-foot blades that spin 5 times faster than any other for a chopper of similar size.
It's just really, really steady.
NASA and its team of engineers and scientists hope to use helicopters like Ingenuity to explore canyons, ice caps, and remote terrain before humans ever land on Mars. Dan Sheneman, NBC News. As they say, what will they think of next? It'd be nice if we could get a warm-up in our next one, Sam.
That's two.
Not everybody wants the same thing. That's why.
Infrastructure, because the plan does things like, yes, bridges, roads, and jobs, but also trying to combat climate change, affordable housing, funding for programs for the elderly and disabled, workforce development, broadband access, and an explicit focus on righting racial injustice. Meanwhile, the vice president promoting the plan with a blunt message to Senator McConnell.
The president and I are ready to keep going, and we are not going to take it slow, and we are not going to take it one step at a time. Nope. We are going to take a giant leap into the future.
I'm joined now by National Affairs correspondent for The Nation, John
Feel like nothing at all, with styles and sizes up to a G cup.
I do not have the time.
All warnings and safety instructions are followed, including removing the safety key. But government data shows there have been 39 incidents with Peloton's Tread Plus, with multiple reports of children being pinned or pulled under the rear roller of the treadmill. One child died.
Have you asked the company to voluntarily recall this treadmill?
We have been in communication with the company. They have not agreed, but we hope that will change.
Tonight, Peloton says it remains open to working with federal regulators, but a recall isn't warranted. Anna Werner, CBS News, Berkeley, California.
All right, we're going to turn now to our special series for Earth Day as President Biden pushes to accelerate a shift to renewable energy sources. Oil and gas workers are being trained for jobs in the green economy. CBS's Medea Videao has more in our series, Eye on Earth, Our Planet in Peril.
In the heart of Texas, green jobs are booming.
Out of the 600 folks we have on site, they're happy to be here and they're happy to, get a paycheck and feed their families.
When it's done in early 2022, the Samson Solar Farm is said to be the largest in the country, spanning over 3 counties.
Some neighbors wanted in right away. Other neighbors, not so much.
Barry Crawford is leasing part of his land in Cunningham, Texas, to the project for 25 years.
Roads, bridges, everything across the line is benefiting.
So it really is giving back some green.
Yeah, it's giving back green in more ways than one. Yeah.
Oil-rich Texas also now leads the nation in wind power. In 2020, the state produced more energy from wind turbines than coal for the first time.
You do not grab the cables.
The Lone Star State quickly becoming the blueprint for a new type of blue-collar worker. Paula Harris recently retired from oil and gas and is now training for a new challenge.
I think this is part of the future.
This site for renewable jobs is run by Lone Star College and WorkRise.
It's about getting them their next job, staying with them throughout the course of their career.
So when you look out into this field, it's not just seeing a solar farm. You see jobs. You see the future.
We see jobs. We see our ability to build to 1 million jobs for America.
1 million jobs for a greener future. Mireya Villarreal, CBS News, Dallas, Texas.
Super smart. All right, there is still much.
See what scholars.
And more so if we zoom out just off to our south. Just south of Des Moines, this band of snow is going to be making its way down toward the Kansas City area. And this is where we actually have some winter weather advisories in effect, none of which are in effect at all across the local Dakota News Now viewing area. Temperatures at this hour are in the 30s and 40s, well below normal. We should be right
within law enforcement. And how widespread do you think it is?
Racism is an American problem. I think that plain to me that there's has been and remains discrimination against African Americans and other communities of color and other ethnic minorities. I think it's reflected in discrimination in housing, in employment, in the justice system. All of these things are still in America. We do not yet have equal justice under law.
David, Gala was here today in Oklahoma City on the anniversary of that horrific bombing 26 years ago. He says the threat of domestic terror right now is high. In fact, he said it's increasing. And David, he acknowledges that some of the same forces that led to that bombing are still at play today. White supremacy, militia extremists, lies, and conspiracies, David.
All right, Pierre Thomas, I know you have much more in the morning on Good Morning America. Pierre, thank you. And when we come back here tonight, the urgent manhunt for a former deputy wanted, now under arrest tonight, found on a rural road. Images from the scene in a moment.
They built
government. Again, the judge in the Derek Chauvin case, the jury now has that case. Let's bring in our panel. Bill McGurn, columnist for the Wall Street Journal. Mara Liasson, national political correspondent of National Public Radio. And Steve Hayes, editor of The Dispatch. Steve, your thoughts on all this?
Well, I think what Maxine Waters said was deeply irresponsible, and I agree with the judge's rebuke. I mean, I think our national leaders in all areas of life, whether elected officials, whether Republican and Democrat, whether parts of the judicial branch, people with a platform should be doing everything they can to urge folks to follow, to respect the process here that's playing out in Minneapolis, and to do everything they can to calm these passions that we've seen. For Maxine Waters to step into the fray and suggest that the protesters increase their confrontation, particularly after what we saw on the streets, whether in Kenosha or elsewhere around the country last summer, is deeply irresponsible.
You know, Mara, Speaker Pelosi said today she shouldn't have to apologize. She shouldn't apologize. But that was before the judge said you may have just handed the defense something on appeal.
Yeah, I mean, look, it depends on what happens with the jury verdict and also what kind of reaction there is. But there's no doubt the one layer of it was this political layer where both sides like to focus on the most extreme member of the opposition party. But to have a judge say that you might have just handed the defendant that you want to see declared guilty a big weapon to maybe overturn a verdict, might be a cell phone, that was a whole other layer of this.
It might just be better.
What he did, though, what I thought was effective, in between his manners of how he argued, or his lack of forcefulness in the way that he argued, he did methodically bring out the arguments that each of these experts did. And he tied it all together by making one strong point, by saying that it was nonsense in responding to the prosecution's completely improper statement in his in his initial summation, by saying that it was nonsense, that none of these other factors of George Floyd, his heart, his drug abuse played any role in this. And I think that if the jury, or at least there are enough people, if I recall correctly, there's a chemist on that jury, or at least there was initially, that if you look at it from a scientific point of view, we talked about the RN maybe becoming dominant figure, but if that chemist is there, or somebody who has some understanding of science is there, they're going to be like, yeah, it is nonsense to say that none of these other things played any role. Now the question comes back to, was Chauvin's knee the substantial cause of death? Or with this, if you look at Dr. Baker's testimony, which was that it's undetermined because there are too many factors here. I think Nelson...
Icy Hot. And Icy Hot now has a bold new look. The possibility she'll enjoy her dream right now.
That there's a lapse somewhere in the double check system with regards to red flags. And so if you have an individual who's already had their guns confiscated, there needs to be maybe a separate section within the statistical data that these people are now housed so that they can be readily identified and not get lost in the crowd, if you will.
This comes as the nation convulses from more gun violence over the weekend, including a 7-year-old girl shot multiple times and killed in the drive-through lane of a McDonald's in Chicago on Sunday. 3 killed, 3 wounded during a shooting at a bar in Kenosha, Wisconsin. 1 person killed and 5 others, including a 12-year-old, wounded by gunfire on Saturday as they attended a vigil for a shooting victim in Columbus, Ohio. 6 people injured when someone opened fire at a 12-year-old's birthday party in a New Orleans suburb. All told, at least 9 dead and several wounded just in weekend violence in 6 states. And since the Atlanta area spa shootings on March 16th, there have been at least 50 mass shootings reported in the United States.
When you see people getting killed, in this last month, it's just been horrifying what's happened. How can you say that's not a public health issue?
What also has health professionals and public officials worried is the idea of Americans simply accepting this kind of mass gun violence.
We must guard against resignation or even despair. The assumption that this is simply how it must be, and that we might as well get used to it.
President Biden hasn't...
Of Mars. Here's CBS's Jonathan Vigliotti.
We can now say that human beings have flown a rotorcraft on another planet.
Spinning its blades 10 times faster than an earthly helicopter, Ingenuity cut through thin Martian air today on a brief but historic flight. 30-year NASA vet Mimi Ong is the lead engineer. It took her team 6 years to nail the technology to make this first-of-its-kind flight possible.
Like a Wright brothers moment, but on another planet.
Ong was born in the U.S. but grew up in Burma, inspired by her mother, who got her Ph.D. in math in the 1960s.
I think she was the first Burmese woman mathematics Ph.D. from an American university.
Your mother, the Pathfinder, and you are a trailblazer.
Absolutely, yes. I feel very fortunate.
There's going to be a lot of kids and a lot of girls who will probably be surprised to see a woman is leading this operation. What's your message to them?
You have to go for it and don't second guess. Don't let anybody talk you out of it.
Mimi Ong, breaking through a glass ceiling nearly 180 million miles away.
Sky's not the limit anymore. Yes, sky's absolutely not the limit.
Jonathan Vigliotti, CBS News, Pasadena, California.
The sky is not the limit, I agree. All right, up next, a former president's mixing his 2 passions, painting and immigration reform.
This portion of where they live, really trying to go to where people are.
So we'll see, Wolf. I mean, we could, get to herd immunity over the summer, but possibly pop out of herd immunity in the fall again if not enough people have been vaccinated. So that's going to be the key.
Yeah, we really have to get people vaccinated. Sanjay, there's another new development I need to talk to you about, and this is it. Exactly 20 years ago today, we're talking about April 19, 2001, a young neurosurgeon began working as CNN's brand new medical correspondent. We have a little surprise for you, Sanjay. Watch this.
I remember talking to you in your office just about the mission of CNN, and I remember, because I wrote this down, to act upon one's convictions while others wait, to create a positive force in the world, to provide information to people when it wasn't available before. I got it. I'm all in. I'm still here. I mean, that was very inspiring to me.
Charity Hospital. Obviously, all the windows are open because there is no air conditioning. We've been here just a few minutes. We're already getting an idea of just how busy this hospital is.
Preparing to treat a patient with Ebola is like preparing to land on the moon.
They're begging for a doctor.
In this case, a 15-day-old baby going to spread maybe within communities. That's the expectation. Does that worry you? Because that seems to be what worries the American.
No, because we're ready for it. We're seeing how some of this relief works.
And suddenly, an 18-year-old mother is thrust through the aircraft door, and this young woman is going into cardiac arrest. It is aggressive, but I just delivered a cardiac thump, a quick, strong hit to the chest, and a last-ditch effort to shock Sabina's heart back into action. Whether it worked or not, I can't say for sure, but she came back. The first known child to be born with microcephaly near the epicenter of the Zika epidemic. He will tell you, when he takes an overdose call, the usual suspect is a painkiller.
There are people with chronic pain who are caught in the middle. There are people with addiction who are caught in the middle. What we're seeing here, is this definitely caused by blows to the head?
When her son Gavin started to become ill, it was subtle. We had heard about this amazing 6-year-old from Colorado who had a rare form of epilepsy. No treatment had worked. And then one day, desperate, her parents gave her a non-psychoactive ingredient from the cannabis plant.
It has medical value, and that's part of the reason I changed my mind on it. Wow, this is pretty spectacular. Just that idea of a true reset. We wanted to go deep into the Amazon rainforest. We wanted to live with the Trimane.
Do something that scares us every day. Get ourselves out of our comfort zone.
Please stand by for a voice check from CNN.
Station, this is CNN. How do you hear me?
I feel like I should be in the back.
There we go. Certainly by now you know the story of Yusuf.
Sharon, look at this. How wonderful.
It's so profound, emotional to see how people react to his holiness. Just to get a glimpse of him. In order to do this operation, they got to continuously move Jaden and Ananias.
This is 3-year-old Jaden McDonald. He's starting to read.
We're joined by our new medical correspondent, Dr. Sanjay Gupta, who's also a neurosurgeon.
You know, Sanjay, the 20 years that we've been working together, I've seen you not only as a brilliant journalist, but you're also, as we just noted, a brilliant neurosurgeon. You've done both. Did you think you would be at CNN for 20 years when you started 20 years ago today?
No, Wolf, definitely not. I mean, watching some of that early tape too, you think I'm surprised they kept me around as long as they did. But no, Wolf, I think it's uncommon, right? You've set the standard, I think, for all of us. But staying in a job like this for 20 years, you do it because you love it. You do it because you think you make a difference. So that was very emotional, Wolf, to see those clips. I mean, it's just, I feel very privileged. I know you do too, Wolf, to be a journalist. It's just so important, especially at this time.
I speak for all of our viewers here in the United States and around the world when I say, Sanjay, we all love you. We are grateful for what you do. Thanks so much. The first 20 have been excellent. The next 20 will be even better. Appreciate it very, very much, Dr. Sanjay Gupta.
Very kind of you,
Our brilliant chief medical correspondent. He's a source of pride. Thank you. Aaron Burnett on Front Starts.
Tonight, the fate of the former Minneapolis police officer charged in the murder of George Floyd, now in the hands of a jury. Deliberations beginning late today after closing arguments in the trial of Derek Chauvin. Prosecutors pointing to images of Chauvin kneeling on George Floyd's neck, urging the jury to believe your eyes. In court, Chauvin removing his mask, showing the jury his face. The defense arguing Chauvin's use of force was reasonable. Tonight, a city on edge, the governor declaring a state of emergency. The new COVID vaccine milestones, all 50 states meeting President Biden's deadline to make every adult eligible today, and 50% have gotten at least one.
With killing George, very apprehensive about going in, out in the public without something to protect.
I couldn't even hold myself. I definitely would have fell if she wasn't there.
The victim of the accident suffered a severe concussion, but is expected to recover. In Palisades State Park, Cordell Wright, Dakota News Now.
First check of the weather here. It's the Challenge Series here in Houston. Could the winter storm disaster that left millions without power in Texas?
He did change the world. I come to you now in the midst of another American crisis, one where we cannot afford to tolerate summer soldiers and sunshine patriots.
Holding his legs for 9 minutes and 29 seconds, the defendant's weight on him. The lungs in his chest unable to expand because there wasn't enough room to breathe. George Floyd tried. This wasn't because even they respected the badge. Even seeing this happening, they cried out at first. Point.
Closing arguments from both sides. The prosecution ending much as it began, focusing on the 9.5 minutes George Floyd spent under the knee of Chauvin. Few cases have captivated the country like this one. Americans shocked by the graphic video of Floyd's horrifying death on Minneapolis street. His face becoming an icon of the nationwide reckoning over race and police use of force. Ed Gutierrez is there and leads off our coverage.
After 45 witnesses and 14 days of testimony, tonight Derek Chauvin's fate is in the hands of the jury.
You can believe your eyes.
During closing arguments today, in excruciating detail, prosecutors reminded jurors of Floyd pinned under Chauvin's knee for 9 minutes and 29 seconds.
George Floyd's final words on May 25, 2020 were, "Please, I can't breathe." He said those words to the defendant. He asked for help with his very last breath.
Floyd's death sparked worldwide protests and reignited a social justice movement.
I'd like to thank the community, and also like to thank everybody around the world for standing together with us in solidarity.
But in the courtroom today, prosecutors trying to keep the jury's focus on the actions of one police officer, not the whole system.
This is not an anti-police prosecution. It's a pro-police prosecution.
Chauvin is facing 3 charges, second and third degree murder and second degree manslaughter. If convicted, the most serious charge carries up to 40 years in prison. But legal experts say a first-time offender like Chauvin would likely be sentenced to much less. After the prosecution finished its nearly 2-hour presentation,
Mr. Nelson, you may close for the defense.
Chauvin took off his mask as his attorney presented his closing arguments.
A reasonable police officer, a reasonable officer, a reasonable police officer.
Using those phrases at least 118 times, playing many clips from the officers' body cameras, and arguing that they showed a clearer picture of the moments leading up to Floyd's death.
The 9 minutes and 29 seconds ignores the previous 16 minutes and 59 seconds.
Attorney Eric Nelson argued that Floyd was actively resisting as a crowd gathered.
This was an authorized use of force, as unattractive as it may be. And this is reasonable doubt. These are officers doing their job in a highly stressful situation.
Late today, the prosecution gave its rebuttal, arguing that Floyd did not die because of drug use or underlying heart condition.
You were told, for example, that Mr. Floyd died because his heart was too big. And now, having seen all the evidence, having heard all the evidence, you know the truth. And the truth of the matter is, that the reason George Floyd is dead is because Mr. Chauvin's heart was too small.
Gabe, after the jury left today, the judge also said the defense might have grounds for appeal because of what a congresswoman said. What do we know about that?
Yeah, that's right, Lester. Over the weekend, Congresswoman Maxine Waters of California said that protesters need to get more confrontational if there was a not guilty verdict. The judge today said that disrespectful comments from elected officials were abhorrent. Meanwhile, there are more demonstrators here tonight outside of the courthouse, Lester.
All right, Gabe Gutierrez tonight. Thank you. As the jury deliberates, Minneapolis and much of America are on edge this evening. Ron Allen now with that story.
Tonight, tension and anxiety across the nation in anticipation of a verdict, especially in the memorial to George Floyd.
I am hopeful. It's scary that it only takes one jury.
I don't have a ton of hope.
Thousands of National Guard troops and police on duty. One team attacked Sunday morning, authorities say, by a drive-by shooter. 2 guards slightly injured. Minneapolis hoping to avoid a repeat of the violence that followed Floyd's death. Over $350 million in damage. A police station destroyed. Nearby, the nightly protest over the killing of Dante Wright by a now former police officer, fueling the tension. More than 270 arrests last week. Today, hundreds of high school students briefly walked out of class, a show of solidarity with Wright. Over the weekend, outrage across the country. Protests from Portland to Charleston. And in Chicago, because of the killing of 13-year-old Adam Toledo by a police officer there last month. Some cities even boarding up, anticipating more trouble. Now, all eyes on Minneapolis. Do you think he will be found guilty of something?
He has to be. So I don't have much faith in his system. However, I am optimistic.
Throughout the day, there's been tremendous energy building here in downtown Minneapolis, with crowds of protesters coming together to demand justice. Lester?
All right, Ron Allen tonight. Thank you. And with all Americans over 16 now eligible for the COVID vaccine, urgent new call.
All of you taking the time. So, Ellie, let me start with you. The jury is meeting right now. So walk us through the charges they're considering, these 3 charges, and the penalties if Chauvin is found guilty of any of them, or whether they can be on top of each other. I mean, just lay this out here.
Yeah, Aaron, so the jury's considering 3 separate charges. Each of them stands alone. They will vote separately on each one. The top charge is murder in the 2nd degree. What the prosecution has to show is that Chauvin intentionally assaulted, not necessarily intended to kill, but assaulted George Floyd, resulting in his death. The middle charge is 3rd-degree murder. The prosecution has to show what we call depraved mind murder, meaning that the defendant created an eminently dangerous situation unsafe for human life. And then the lowest charge is manslaughter, and the prosecution there has to prove what we call culpable negligence, meaning Derek Chauvin created an unreasonable risk to George Floyd. Laying over all this is the issue of medical causation. Did Derek Chauvin's actions cause George Floyd's death? The defense actually misstated that today during their closing. They said if other factors were involved, then you have to acquit. That's not correct. The prosecution corrected it. The judge eventually corrected it. As long as Chauvin's actions were one contributing cause, that's enough for the jury to convict.
All right, and just to be clear, Ellie, do they have to pick one of those charges? I mean, they could go on none of them, but they can't go on more than one, correct? You got to pick.
They can convict on all 3. They can convict on 2, 1, or 0. Yes.
Okay. All right. So then, when you look at your times here of how much time you can spend in prison, obviously that becomes additive, and I know the judge will eventually set that as well. Nevertheless, Blake, let me ask you then about Chauvin's defense attorney voicing concerns after the jury left the room about whether they've been able to avoid, you guys, you all and everyone else coming on every night and analyzing this and taking this apart night after night. He specifically brought up Congressman Maxine Waters, who said today who said this when asked what protesters should do if Chauvin is found not guilty. Let me play what she said.
We got to stay on the street, and we've got to get more active. We've got to get more confrontational. We've got to make sure that they know that we mean business.
And she explicitly said that he was guilty of murder, she said. Here's what was said in court about her comments.
Now that we have U.S. representatives threatening acts of violence in relation to this specific case, it's mind-boggling to the judge.
Well, I'll give you that Congresswoman Waters may have given you something on appeal that may result in this whole trial being overturned.
I mean, Mayor, as a mayor and also a former defense attorney, I mean, this is pretty stunning. I mean, the judge in the trial said Maxine Waters may have done something to cause a verdict here to be overturned. It's pretty incredible.
I think if you would listen to the judge, he's very careful with his words. So he really underscored the seriousness of what was said. And I think everyone understands her background. Everyone understands she comes from a civil rights background. She comes from a protest background. But speaking as someone who has been on the front lines fighting for police reform when no one, when the legislature was really deaf to the concerns that I was raising, we need other elected officials to stand with community members, go to testify, help them understand the process of moving forward with police reform. That want real police reform, that want to rethink policing, and the mayors, I shouldn't say we, those mayors need assistance, not confrontation. They need allies, and they need people to help testify and shape the policy moving forward.
So, Alan, the jury, as I said, is deliberating right now. We know their views about this case may be complicated. I found it was fascinating today to read through everything we knew about them. They had filled out an extensive questionnaire before they were selected to be on the jury. One juror, a black man in his 30s, told the court that he told his wife after Floyd's death, "It could have been me." But then he strongly agreed, again, that was his, check strongly agreed, that police in his community make him feel safe. A black woman in her 60s, also on the jury, said when asked about Black Lives Matter, quote, "I am black and my life matters." But then about Blue Lives Matter, she said, "My family member is a police officer and all lives matter." So when you look through all of these details, Alan, what does this tell you about what's going on in that room right now, likely?
This is a very diligent jury. They're nuanced, and they have a lot of middle-of-the-road tendencies because the ones on the extreme ends, on the margins, were eliminated. So as you said, I think there was also a juror who said he witnessed a police harass somebody, and at the same time he has friends who are police officers. So when you look at those questionnaires, it indicates one thing and then goes to the other. So this is a very diverse jury, and jurors see things through many different attributes: race, gender, their experiences, their occupations. And the jury is much more diverse than Hennepin County is. And this bodes well for a very rich deliberation. I've seen observationally, and the literature is replete with evidence that the more diverse a jury is, the more viewpoints they consider in deliberations, the more accurate their recall is of evidence, and they tend to approach deliberations with much more rigor and determination. So it'll be a fascinating deliberation as they set over the evidence and all the testimony.
Shirley?
As we switch out from snow and frigid cold, we now have to prepare for severe thunderstorms and even tornadoes. This week is South Dakota's Severe Weather Preparedness Week. There will be a statewide tornado drill starting at 10:15 Central Time Wednesday morning. It's important to have a plan ready for
Tesla with autopilot engaged, now approaching 10 times lower chance of accident than average vehicle. The federal government is investigating more than 24 Tesla incidents, including a driver in Boston reportedly asleep at the wheel.
So I did a double take. This guy was just head between his legs, completely asleep.
Now 2 agencies sending investigators to try and unravel another tragedy. Sam Brock, NBC News.
As I said at the top of the broadcast, we're in Houston to begin NBC News cross-platform coverage of the climate challenges we face. And while it's warm and pleasant here today, a series of extreme weather events in this region have left a lingering chill about its future. It broke virtually every rainfall record in U.S. history. 4 years ago, Hurricane Harvey washing away nearly everything in the Beal family's home.
Water was everywhere.
In the house?
In the house, coming from up under the house, coming from a roof.
The family of 6 was still rebuilding from that catastrophic storm. Then came February's crippling freeze. Their pipes burst. For days they had no power, no water. They had to move out again.
What was that storm like?
It was terrible. It was painful.
How cold did it get?
All about 5 degrees in there.
Extreme weather from those hurricanes and winter storms in Texas to California's heat wave last summer that led to rolling blackouts, growing more frequent and severe.
And that has revealed vulnerabilities in our critical infrastructure. Here in Texas, the power grid failed during the deadly cold snap in February. People were trying to heat their homes.
plants couldn't keep up. And that, say experts, should be a warning to the rest of the country.
If we do nothing, then it looks like climate change is going to get inexorably worse.
Cheryl LaFleur is the former chair of the Federal Energy Regulatory Commission. She says we must put the work in to build more reliable and resilient power grids.
It's really a double strategy. We need to fight climate change. At the same time, we need to be ready for storms because we can't make everything perfect tomorrow.
She points to possible solutions, like building better connections between power grids so energy can be diverted when an area sees a spike in demand. And she says power plants need to be modified so they're better prepared to withstand all kinds of weather. After more than 100 people died in the February storm, some officials here in Texas are pushing to winterize the system so natural gas, coal, and nuclear plants stay online, and renewable energy sources like wind turbines don't freeze again.
What happened in 2021, quite frankly, in large part was foreseeable and preventable.
Sylvester Turner is Houston's mayor. So if we do nothing, what happens to a city like Houston?
If you don't do anything, then you're going to repeat this movie over and over again. And it's going to cost in terms of people losing their lives, people losing their property, and it's going to affect the overall economy.
Meanwhile, Craig and Angela Beal are still rebuilding and bracing for Houston's scorching summer when the grid could be tested again. Do you think this is going to happen again?
Yes.
I know it's going to happen again.
I believe it's going to get worse. As the years go by, it gets worse.
Hurricane season officially starts June 1st. However, government forecasters plan to begin issuing routine tropical outlooks in mid-May this year. Tomorrow, Richard Engel on how war caused an environmental...
That's how far south it's going to go. Let me show you what's going on here in the national view. So you can see kind of that area of snow to our south from Nebraska into Iowa right now, and that continues to push southward. So that's the same, basically the same cold that moved through here yesterday and really changed our temperatures around, you know, from the 60s like a lot of us had yesterday to the 30s and 40s today. So there's that snow down to the south. Look for the well seal.
Look for the well health safety seal out.
You see what you pay before you trade.
From behind him, startling. All of these facts and circumstances simultaneously occur at a critical moment.
So there's Eric Nelson making his point at the critical moment. George Floyd breathes his last, and then you hear in the video, you know, it gets a little loud. So Darren Porter, it's back to that.
My name is Ronan Murtha, and I came from Dublin, Ireland.
Professionals feel confident in
and only sustainably farmed the
rather quick.
Thank you for being here. We've been in touch with those families. Can't imagine their pain right now, but just give us a sense of what they're going through right now, what they're telling you.
Yeah, you know, the SIOUX who lost loved ones in Indiana, as you can imagine, they're hurting, they're grieving, they're outraged, and they're frustrated, and they're also filled with determination and resilience. And as I've listened to surviving family members, I've heard a fierce determination that their lives will not be lost in vain, and that moments like these are catalysts for meaningful action. And like all groups, the beauty of the Sikh community is that it doesn't have just one feeling about such a tragic event. The attack evokes historic trauma, feelings of deep solidarity with all of the impacted families, and it forces all of us to engage a very difficult and a very public conversation about what it means to be American today.
Simran, as we mentioned, the police are still investigating a motive if one is to be determined, but among the community on the ground, what is the feeling? Is there a sense that they were targeted in some way?
Yeah, you know, I don't know what the officials will conclude, but I'll share what we can see. That a disturbed young white man who shouldn't have had access to guns targeted a FedEx facility where Sikhs make up a large and visible population of the workers. And he killed Baptists, and he killed Sikhs. And, you know, at the end of the day, a life is a life. And at the same time, we can't look away from the pattern of hate violence that's targeted Sikhs in the recent past, including the 2012 massacre in Oak Creek, for one example. So as a community, We're facing steep challenges, ranging from the farmers' protest in India to standing shoulder to shoulder with groups targeted by white supremacists across America. And our faith guides us to do so in ways that uplift ourselves and others, especially during difficult times like this one.
You mentioned that mass shooting that did target the Sikh community in Wisconsin back in 2012. Among the community, for families in there, can you tell us, even all these years later, how is that impact still felt?
No, the impact of something like that never goes away. When your community is targeted, it leaves a scar in your collective psyche. And you know, the Sikh community is a visible, politically engaged, and spiritually aware community. And there are times like after 9/11 and after the Oak Creek massacre where we felt targeted, even if Americans couldn't clearly describe who a Sikh is. And today we see ourselves as an active force, building a more just, a more equitable America. And in the process, we know that our high visibility will make us targets. And although the reason for the targeting may change over time, our visibility puts us on the front lines against a regressive and a racist vision of America. And I think that part of our experience, this courageous vulnerability, that's part of our tradition too. And it's one that comes with a steep cost, but it's also a commitment that I'm proud of and that I know many Sikhs are proud of. And I don't see any of us giving up on our commitments anytime soon.
Well, our hearts go out to all of those who lost a loved one in Indianapolis, and we're grateful to you, Cmgus Vcr of the Sikh Coalition, for joining us tonight. Thank you.
Thank you. Look forward to be with you.
In the day's other news, everyone in the United States, 16th, and I look vaccination. Last few states took that step today.
Closing arguments knowing that this is now in the hands of the jury.
I mean, it was something to see. I mean, even Gianna was in there. You know, his daughter was actually in there. She watched the closing arguments with Roxy, and it was the entire family there, watching and just waiting for justice.
So, will the family accept a conviction on any of the charges, or only a conviction on the most serious charge, which is second-degree murder?
I mean, look, we want second-degree murder, but more than a specific charge, we want him behind bars. But of course, like everyone else in the world, we want second-degree murder.
So, you know, the defense attorney today focused in his closing arguments saying, well, it's not just about the 9 minutes and 29 seconds. He's trying to say, look, it's about everything that happened before and everything that happened after and all the context surrounding it. Here's part of what he said, Chris.
Officers know that they are being videotaped. They know they're being videotaped by themselves. They know they're being videotaped by bystanders. They know they're being surveilled by the Minneapolis Police Department milestone camera, right? They know these things. Do you do something purposefully that you know is an unlawful use of force when you have 4 body-worn cameras immediately in the area, where you have multiple civilians videotaping you, where you know your actions are being reviewed through a city-owned camera where there are surveillance cameras?
What's your reaction to that, Chris?
It's ridiculous. Of course you would behave the way that Derek Chauvin did, because he felt invincible. He had gotten away with all his other past transgressions. He had gotten away with his prior use of force with his knee. Why would he think he would get in trouble this time? These are just some poor black people recording him. He's in the inner city. Why would he feel like he could be touched? Well, he got touched. And that's what's shocking to him. He's not worried about the body cams. Normally, body cams be turned off. They fall. They aren't checked. He's not worried about that. He knows how to manipulate the system. But this time, it didn't work. So when, you know, the bell rings and you get caught, it's hard to accept it. So that's why they don't want to focus on the murder. They want to focus on the time period, which has nothing to do with his death.
So let me ask you about the comments from the judge today, or what the judge said about what Maxine Waters said, the congresswoman. You know, as I played earlier, she said, and I want to quote her, "I hope we get a verdict that says guilty, 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 and if we don't, we've got to get more confrontational. And that's just part of what she said. The judge responded saying that her comments created something on appeal that could result in this whole trial being overturned. Did that bother you, hearing this and knowing what caused it?
No, because her words could have been interpreted as being more confrontational by speaking up. Most African Americans, when they're racially profiled or harassed, say nothing. They just take it on the chin and walk away without complaining, without going to the police department and saying something was wrong, without saying I was abused. That's what she could have been talking about. She wasn't talking about going riot or do anything, crazy. That's ridiculous. The family doesn't want that. She's not talking about that. They were just trying to take their basketball and go home because they're losing. And trying for a mistrial is the biggest evidence that you just got destroyed at trial. So we didn't buy it. It was a last attempt effort to get away from the jury verdict. And we have faith in God that it's going to be guilty.
All right, well, Chris,
One successful inoculation campaign, many remain resistant to the shot. How NASA's ingenuity makes space history by taking flight on Mars. Oscar nominee Andra Day on the painful history in the United States versus Billie Holiday. Plus, much more.
1995. What a relief.
This is a breaking point, for the community there. I mean, I don't know how much more people can take, honestly, nationally, but you can speak for the community there.
We've already reached our breaking point, and to Michelle's point, she talked about some of this in her book a long time ago. And people started to have these conversations around race, but unfortunately they stayed in a Minnesota nice bubble, and they didn't go out and try to critically examine the systems that are producing this oppression. So we've already reached a breaking point. That's why we take it to the street. That's why we've shut things down. Many of us ran for office. So in 2017, I ran against Jacob Fry on a police accountability platform, and I said, if we don't rein in MPD, we're going to become the next Ferguson. They didn't listen. Why? Because they don't listen to Black people. The evidence is there. The statistics are there. But they want to continue to appear progressive, and that means silencing the voices of those whose experiences don't mirror white Minnesotans. And even now, our government leaders are speaking all this rhetoric. They're not serious about transforming systems. It's going to be the people who make that happen.
Michelle, the Rodney King case was in 1991. George Floyd was still being accused of his own murder with the exact same terms, he was going to jump up from the dead and be a threat. Do you feel like, Groundhog Day was a good way to put it, I guess.
It hasn't, we're seeing that defense all over again. And, he offered us a smorgasbord of excuses for why this was, reasonable policing. This moment invites us to think about what reasonable policing looks like. Because you have to ask yourself if what you saw in that 9 minutes and 29 seconds was reasonable policing. And to the point made earlier about Minneapolis and Minnesota really being a progressive state, in some ways it makes it even harder to have these conversations. Because the hardest people to awaken are the ones who think they're already woke. And so, a moment like this will perhaps open people's eyes again to, what's happening with policing, and that there will not just be a conversation, but a dismantling of the system all the way out, all the way down to take it apart and build it back up and again in a way that the department truly is there to protect and to serve a public that right now does not trust them.
Yeah, I think you two just said a word.
Who knew vocal coaching from Snoop was a secret? Hello.
Dear road rivals, charging extra for safety is where we part ways. See, I ride with standard Toyota Safety Sense.
Choose our
garage with a new Chamberlain.
But on my road,
that's our time. Thanks for watching.
Good evening.
Stop. Yoda, let's go places.
it's America's game.
This is Dakota News Now.
We've got 6:30 here on KDLT. Thanks for joining us. I'm Sam Wright.
And I'm Kelsey Passel. With Minneapolis and much of the country watching, prosecutors and the defense getting their final word with the jury today during closing arguments in the Derek Chauvin murder trial.
Outside the courtroom, tensions, much like the security force, are growing. NBC's Jay Gray has our top story here at 6:30 from Minneapolis.
He did what he did on purpose. And it killed George Floyd.
Calling Derek Chauvin's actions an abuse of power, an assault, and betrayal of his badge. Prosecutors tell the jury, you don't need to look much further than the images from that day, including the video of George Floyd's dying moments, to understand this case.
You can see this with your own eyes. You could see what happened, that he couldn't breathe. He said he couldn't breathe.
Working meticulously through testimony from the state's experts while often discounting those from the defense, at one point reminding the panel of Floyd's screams with Chauvin's knee across his neck.
For 9 minutes and 29 seconds, he begged, George Floyd begged until he could speak no more.
9 minutes, 29 seconds. It's not the proper analysis, because the 9 minutes and 29 seconds ignores the previous 16 minutes and 59 seconds.
A struggle defense attorney Eric Nelson says framed the events and Chauvin's actions that day. The former Minneapolis police officer removing his mask, facing the jury as Nelson reviews use of force requirements, telling jurors Chauvin never violated police policy.
These are the actions of a reasonable police officer.
A phrase
A reasonable police officer
he used often during his time with the jury. Continuing, Nelson pushes on the defense theory that Floyd's heart, his use of drugs, and the crowd that gathered all played a role in his death. The jury returned to the courthouse this morning, prepared to stay for a while. They'll be sequestered until they reach a verdict. Jay Gray, NBC News, Minneapolis.
While the jury deliberates, Minnesota and states nationwide are preparing for reactions on the jurors' verdict.
Minnesota leaders, including Governor Walz, spoke out tonight about the possible reactions. Jacob Sersosimo has been following this story for us and joins us from the Now Desk with more. Jacob.
Yeah, Kelsey and Sam. Last summer, Minneapolis and cities nationwide felt the impact of unrest after the death of George Floyd. And as the world waits for the verdict, Minnesota leaders are preaching peace, systemic change, and safety. Now, this is a live look at the protests that are currently happening right now, and they're underway in the streets of Minneapolis. Now, Governor Walz tonight, along with the Minneapolis and St. Paul mayor, are speaking out about issues surrounding their city and state right now. Governor Walz focusing on the systemic issues in society and the need for change, the need to listen to the protesters and not let a traffic stop turn into a death. Walz showing frustration around creating laws to help protect against a situation like this one in the future. The governor also talking about the need to provide security and safety for houses and businesses.
I hear those concerns who fear for their businesses and their homes. We need to provide the security, and we're prepared to do so. But I also, at the same hand, want to hear. I hear those decrying their inability to protest and what they believe is heavy and too much is out there. We need to strike that balance. I'll be the first to tell you, this is not the way to live. We need to fix those other things so we don't have to end up with National Guard on our streets.
Now, we will continue to follow these protests in Minneapolis closely tonight and keep you updated on the jury verdict when that time comes. Live from the Now Desk, Jacob Sersosimo, Dakota News Now.
Jacob, thank you for the update. We turn now to meteorologist Tyler Rooney for a check of our first alert report.
The Pfizer 2-shot vaccine.
We lost 2 dentists in Ramallah from the pandemic.
That's the issue. This is a public health issue. It's not a civil liberties issue.
Once again, Dr. Fauci proves that he has no regard for your liberty and is perfectly happy to restrict your freedom in the name of public health.
The trial for a police killing has brought outcry and protest nationwide. Those protests have also brought more evidence of aggressive policing. On Friday in Brooklyn Center, after protesters pushed against a fence surrounding the police station, police responded with tear gas and pepper balls, and more than 136 people were arrested. No journalists were among those arrested, but several covering the protest alleged police harassed them, forced them onto their stomachs, and took pictures of them. Meanwhile, there were massive protests in Chicago over the police shooting of Adam Toledo, demanding justice for the 13-year-old who was shot with his hands up on March 29th. With the verdict in the Chauvin trial now in the hands of a jury, the country is now bracing, not only with outrage over the ongoing crisis, but also for what comes next. And joining me now is former Detroit police officer Ralph Godbee. And Chief Godbee, can we address this issue of police responding to protests about police brutality with brutality?
It is the most counterintuitive thing that anybody could do, Joy. And you can't make sense out of nonsense. That has become one of my favorite sayings. And my heart is just so heavy today. Just looking at what law enforcement is, I don't believe at all that Malcolm, Meg, or Rosa went through what they went through for us to be at the state of policing that we are in the United States right now. And, I'm afraid to say, people are afraid of the word defund, but what industry can you pay for something and the people that you pay have the power to kill you indiscriminately when they get a chance to? Who would pay for something like that? We have to have the conversation, because to do the same thing the same way and expect a different result is the definition of insanity. And there has to be fundamental on-the-ground change as to what law enforcement looks like in the United States.
Thank you for saying that, because I think people keep forgetting. Police are the employees of the citizens they're protecting and serving. The second part is serve. And so particularly in black communities where more tickets are written to glean, to glom money off of these communities by having people write tickets, black communities and brown communities are literally paying the police to kill them. It actually is bizarre.
Literally paying for it. And Joy, you bring up something that I think people really may not have an appreciation for, why we have to structurally change police. It's incentivized for officers to write tickets, because if they write tickets, they go to court. That's extra duty. So if you've got a bill that you need to catch up on, you write some extra tickets. We as law enforcement, we have lost, and we do not deserve to have the unfettered just ability to use discretion in pretext stops, in issuing tickets. If you look at any vehicle code in any state in the United States, it is so voluminous that you can justify stopping anybody. And we have to wrestle that back. Citizens need to get control of those types of things. Some of the things, even looking at Dante Wright, the fact that even there's a specter of the fact that he was stopped for obstructed view because he had air freshener hanging from his mirror. I dare you to go into an affluent white community, rich suburb, and make a stop, a Bentley or a stop of a Mercedes-Benz of a corporate individual. That person would be in the mayor's office yelling and screaming, demanding that person's job. Yeah, this is what's enforced in our communities routinely, and it's a ruse. It's not for protection, and it's not protecting our communities, and we need to take an oath somewhat like doctors, the Hippocratic oath. Do no harm, and we're doing too much harm to black and brown communities.
And I'm so glad you're saying all this, because we have on one weekend an oath keeper talking about how, we got police in here. Police are part of the Oath Keepers, the people who helped storm the Capitol. You've got the Proud Boys, all of these stories, New York Times now is covering too close relationships with police. Police among those who stormed the Capitol. There are so many reasons for people to just have a basic lack of trust for policing. I mean, the George Floyd Act is out there. It's, it has some good stuff in it. Is there a law that you could pass that would fix this? Because it feels like police in the consent of the governed. We do not consent to having police use us for revenue, like revenuers, glom money off us with pretextual stops, and then kill us when we don't comply. This is not something that no community would ever consent to, but police are demanding that black people consent to it. Is there a law that can fix this? What fixes this?
So I think this is where there has to be a national initiative to enforce some of these things, because there are 18, and your previous guest was right on point. There are 18,000 police agencies in the United States of America, give or take. Average of about 50 officers. So we get so excited and say, I have a good chief. Well, that's one out of 18,000. And systemically, you cannot make the necessary change. So what I would opine, we have to look at a different way of funding law enforcement. Courts cannot be driven by revenue from the communities that can least afford it, because you're robbing those communities of resources and you are creating criminals. The second thing, you have to find a different way to compensate police officers. Number one, we don't need as many as we have because we're over-policing in our communities. But we have to find a different level of compensation, because if there is a financial incentive to your enforcement, it is ripe for corruption. And then you add to that, and this is no secret, this is not new. The FBI told us years ago that white supremacists were infiltrating the ranks of police departments, i.e. Proud Boys, i.e. the Ku Klux Klan. They don't even have to wear masks anymore. They put on uniforms and they terrorize our communities. So we have to make that change. If this country is going to rebound and be what it potentially has to be, and I put out a challenge to President Biden. Black people put you in office, and we need you to stand tall for us and make the change necessary. If you have to get rid of the filibuster, whatever is necessary to protect black and brown people from being killed indiscriminately by police, it needs to be done.
Well, you can get an amen. It's not Sunday, but you can get an amen. I hope that the president gets in touch with you. Ralph Gotti, thank you so much for everything that you said tonight. President Biden, call Abby. He has some good ideas for you. Thank you very much, sir. And there also is a difference. Wow, that was real. There is a difference between the GOP flirting with the idea of white supremacy and just bringing it in for a big old sloppy wet smooch. Of course, if you're going to just go ahead and form a white supremacy caucus in Congress, that puts you in the running. To me, it's absolute worst. Stay with us. Ooh,
Your medication, AstraZeneca, may be able to help.
To see the world. Guaranteed. Easy to get started with a virtual or at-home.
Shouldn't be one. Moisture in your crawl. For skill missing and memory.
Some polling that suggests it's very popular, others that say it's kind of but it suggests that both sides have to fight here to define what exactly this is. For Democrats especially, it's how to pay for it, which is leaning into the issue that seems, at least in all of these polls, to be favorable for Democrats, and that's paying for it with higher taxes on wealthy people and for higher taxes on corporations, raising the tax rate on corporations. People seem to like that. But as we know, some of the details and how people perceive not just the message, but the messenger. Do they trust Democrats to follow through with what they say? Republicans, of course, saying it's
Be tools, the power to.
That's from knowing, and we mean a long time.
You can now go to young people and say, guess what? If we protest, guys, keep it peaceful, vote, and put in good people, you can get a good outcome. If you have any other thing that goes down, it becomes hard to keep people in the system. It becomes hard to get people to vote, and you go down a very, very bad path. Which my fear is that you can't go back to this generation and say your protests matter, your voting matters, your elected officials did the right thing. If you don't have that, you have a very, very difficult time going forward.
Gentlemen, thank you very much. I appreciate the guidance, as always. This is living history. We are going to figure something out about the country now, not just in the case, but in the reaction to the case. And Van, your point was forgotten, and it is well meant. We would have never gotten to this trial if the situation had been as normal, status quo. It is only because this case, as egregious as it was taken out of local hands and put in the state, the Attorney General of the state, that you got it. Remember that. It wasn't obvious at the beginning. Barb, thank you, Commissioner, as always. Van, appreciate you. So, they're still deliberating. I can't believe it's going to go that much longer tonight, again, unless, and I don't know that we'll get word if this happens, but unless they go to the jury and say, are you close? Are you getting somewhere? We just got word the jury is finished for the night. Not on you, okay? Not in the case of this magnitude. They have a number of charges, all that meet the same behavior. I'm sure they're taking their job very seriously because this is heavy. They know what this is about. They know they're about the facts and the law, but they know what's going outside that courtroom as well. So they should take it seriously. They should take their time. They will reconvene in the morning. I expect that you have, if you don't have a verdict in the first half of tomorrow, you have a situation within that jury where there's obviously one or a few people who are insistent that they can't find a meeting of the minds with the rest of the jury. And that's when a hung jury becomes an issue. And if you have it, then it's a question of whether or not you can re-prosecute, and that's what prosecution. One step at a time. They've gone home for the night. Now, when we look at the legal arguments, prosecution's argument was very simple to me. It was believe what you see and apply common sense. The defense said it's not easy to see it because you can't see inside what's happening to Floyd. Now they also said Chauvin could have done more. He could have used more force and didn't. I don't get where they were going with it. Luckily, I have two great, brilliant legal minds from two other very high-profile trials, but they have a ton of experience beyond them. The prosecutor of the Freddie Gray case and the lead defense attorney for the man acquitted in the killing of Trayvon Martin. Next.
At Fidelity, you'll work with
his popularity, but he made a different kind of history by choosing the first female running mate on a major party ticket, Geraldine Ferraro. Walter Mondale was 93. The fate of former Minneapolis police officer Derek Chauvin now in the hands of jurors. 12 jurors are deliberating if Chauvin is in any way responsible for the death of George Floyd. During closing arguments, prosecutors claimed Chauvin squeezed the life out of Floyd by pinning his knee against his neck. The defense argued that Floyd died of an underlying heart condition and illegal drug use. I'm Trace Gallagher. Now back to Sean Hanning.
Welcome to Hannity as we continue as we're broadcasting from Mar-a-Lago, Palm Beach, Florida, where we are joined for the hour. President Donald Trump is with us. I want to go to this next question. I want to talk about the future. There is the Trump agenda.
And we give it to the government in trust for us to hold and to use appropriately. But sometimes we take it back. Sometimes when something is really important, we reserve those decisions for ourselves. The state, we have power. We cannot convict the defendant. The judge has power, but he cannot convict the defendant. That power belongs to you. You have that power, and only you have the power to convict the defendant of these crimes, and in so doing, declare that this use of force was unreasonable. It was excessive. It was grossly disproportionate. It is not an excuse for the shocking abuse that you saw with your own eyes. And you can believe your own eyes. This case is exactly what you thought when you saw it first. When you saw that video, it is exactly that. You can believe your eyes. It's exactly what you believed. It's exactly what you saw with your eyes. It's exactly what you knew. It's what you felt in your gut. It's what you now know in your heart. This wasn't policing. This was murder. The defendant is guilty of all 3 counts. All of them. And there's no excuse. Thank you.
Closing arguments today in the Minneapolis trial over the death of George Floyd. The jury now has this case. We've just been advised within the last hour that they have ceased their deliberation for the night, which means their deliberations will start again tomorrow. We don't know how long they will deliberate for, but the whole country, obviously, waiting on that verdict for lots and lots of reasons. Joining us now is Philip Atiba-Goff. He's a professor of African American Studies and Psychology at Yale. He's a co-founder and CEO of the Center for Policing Equity. Professor Goff, thank you so much for being here tonight. It's a real pleasure to have you.
Thanks for having me.
It strikes me that we are on tenterhooks waiting for this verdict. Before we get it, though, I wonder if you think that this has been either an educational or cathartic or potentially regressive moment for the country to have the whole country watching this trial for 3 weeks now.
Well, it's not the first trial like this that we've had in the United States. I mean, I've seen a number of folks looking at the trial of the officers who savagely beat Rodney King and the same exact kind of arguments being made by defense. We've had trials of folks who have been obviously demonstrably guilty of savage acts before, and the country and the world watched to see what the heck would happen. I don't know that there's an inflection point here unless we choose differently. I mean, I'm really struck, actually, by the way in which always, every night, you put all of the lead stories into context, but there's so much going on. There is the fall of the U.S. stature on the international stage. There is our infrastructure crumbling. There is our Justice Department that needs to be put back together. But what strikes me about all of that happening around this trial, the reason why there's this shadow looming over all of it, is because every piece that is broken, that needs to be made whole, it was once okay. It was once something that was really good about this country, that people who lived here could be proud of, and that was the envy of the entire world. But not racism. We've never gotten that right. We've never had a criminal legal system that treated everybody equally. So if we've got an obligation all to one another, maybe we can do that on our roads and bridges. Maybe we can do that in the Justice Department, on our foreign policy. But the one thing we can't have in historical context is the only time we ever got racism right. So I think maybe part of the reason why it feels different is because we're hoping this time is different.
Hearing Attorney General Garland today talk about, while he was having an emotional moment thinking about his family's own history in the United States, saying, in America, we have to protect each other. We have to make sure that we all are protected. That was the reason I wanted to play that sound, is that it just undid me. Seeing that lens and seeing that value being articulated by the nation's chief law enforcement officer. You know, after I just listened to the first policy speech from our first African-American national office holder, the vice president today, and just seeing through that lens into the way that all those bystanders felt so hopeless, and the way people watching this trial and watching these jury deliberations and waiting for their verdict today feel impotent, feel hopeless, feel cynical, feel like there's nothing that can be done because we can't even imagine this working. It's almost like the thing that we need to invent here is hope that it could get better.
Well, and that's why we're sitting here waiting on it. I mean, on one level, it's absurd to have to wait. And I just want to clarify, I understand that the charge here is murder, but what we witnessed was a lynching. That's part of the reason why it's important to put it in historical context. It was a public message to people that what Officer Chauvin was doing was okay, and you might be next. So part of why we're sitting here is because of the absurdity that there's any suspense about this at all. We all watched it. But the other part is exactly that. I mean, there's no way to actually get justice for George Floyd. He's not going to come back alive. There's also no way to get remedy for the children who had to take the stand and say, yes, in my formative years, this is what I saw, and I knew it was wrong. And the person who had authority and to take away life and liberty could not get up off a man's neck. There will be no remedy through this court process for anybody. There might be a measure of accountability, and the fact that that would feel like something new is an indictment. It's just an indictment for a case we haven't yet really put on trial. And the hope is, on the other side of something like sense in this particular court case, that we'll do something different for the first time on racism and punishment in this country. For the first time. I can't overstate it, because in all of our history, we're looking for the example that makes this right, the place we can get back to, and there's no going backwards to find comfort. The only possible comfort is what we choose to do next.
Philip Atiba-Goff is a professor of African American Studies and Psychology at Yale University. He's the co-founder and CEO of the Center for Policing Equity. Philip, we're all watching this with I think the same dread and anticipation tonight. Thanks for helping us put it in perspective. All right. We have eyes on Minnesota tonight as the jury deliberations have wrapped for the evening. As we mentioned, there is National Guard that's been activated in Washington, D.C. There's also been National Guard activated over the past week in Minnesota after there have been nearly a week now of protests over the death of Daunte Wright, about 10 miles away from where the George Floyd trial has been held these past 3 weeks. There's a lot going on tonight. Lots of more news to get to. Stay with us.
When you have died,
people might say it was a bit of a shotgun approach. You have to be careful with so many alternatives that the jury just goes numb to all of them. But if you're trying to find reasonable doubt, maybe it is reasonable doubt in the meth. Maybe it's reasonable doubt in the fentanyl. Maybe it's reasonable doubt in the heart. But at the essence of what the defense should be doing, and I don't know that Nelson brought this home, was to say, look, certainly there is reasonable doubt as to the higher offense or offenses. And if you have a question about that, if maybe it was the fentanyl, maybe it was the meth, maybe it was his resistance at some point, maybe Chauvin truly did not have that ill will in his heart. Maybe he was following poor training. Then let us go down to what you might look at. And he didn't say it, but I almost wish he had given the jury a path, not permission, but a path to go towards that manslaughter charge, because quite honestly, and I think Ms. Mosby might agree, a manslaughter conviction in this case would be a gift to the defense and would be a win for the defense. So maybe he could have done a better job of opening up that possibility for the jury to consider, because though it's very difficult to convict a cop of anything in this country, under these facts, they may well, and then it's the defense job to lessen what he's convicted of.
What did you think of the fact, Marilyn, that the defense attorney argued he could have done more? Chauvin would have been justified in doing more. I didn't get to see the jurors' faces on that. I heard that they were a little tired. It took a long time. But what was that about?
So I wasn't impressed with the defense strategy, which in my opinion was the same that it always is in police misconduct cases, which is to stigmatize and to criminalize and blame the victim for their own death. I think that the defense sought the introduction of Floyd's drug use, his heart condition, and even the carbon monoxide poisoning to impose doubt in the minds of the jury. But that was done to invoke these conditions as contributing causes of his death. I think the defense really went wrong. Where he really went wrong was putting an expert on the stand that testified that Chauvin's use of force was not only objectively reasonable and justified, but he could have used even more force against Floyd because he was allegedly resisting. This type of stigmatization and criminalization and blaming the victim for their own death was done in the killings of Freddie Gray, Sandra Bland, Philando Castile, Mike Brown. It will likely be the defense and even Dante Wright. The carbon monoxide defense was one that the defense just threw against the wall to see if it would stick. And I didn't think that it was effective.
Well, Mark, here's the problem. Not only do you have 3 different charges that go to 3 different states of mind for the same behavior, which could be a little confusing, but I actually think it's more of a convenience for the jury. He may be right that fentanyl was involved. He may be right that, you know what, one of these people in this room has some kind of savvy medically and says, I got to tell you, that heart doesn't look right. The standard is very simple and was pounded into their heads. That knee didn't have to be the only thing that killed him. It doesn't even have to be the main thing that killed him. It just has to be one of the main things. And the case law, you know, they didn't explain it this way, but it really points to the top 3. I mean, that's tough to get away from, is it not? Mark, last word to you.
Sure, very, very difficult, and that was the problem with this case from the beginning with the defense, was it wasn't show if and only if this one cause led to the death. It literally was a substantive or substantial cause and causative factor, and unfortunately, that's what the statute requires, and the defense had a very difficult time wrapping their head around that, and they had a very difficult time trying to come up with a reasonable explanation as to why reasonable doubt exists as to that issue, as to it wasn't a substantial cause. And what they did, again, was this sort of shotgun approach of saying, I can cut back on the substantiality of this cause of death if I can show you all these other contributors, and maybe you'll add all the other possibilities up and find the first one, the cause of death by Chauvin's knee, didn't rise to the level of beyond a reasonable doubt conviction. But very difficult case for the defense to put on. We'll see in probably a few hours tomorrow what the jury thinks.
All right, thank you very much, Marilyn Mosby, Mark O'Mara. I thought it was really interesting. One of the things that the prosecution said was, you're not required to accept nonsense. You're not required to accept the proposition that the car did it, or that it was the bystander's fault distracting the defendant. They were very careful about what they did. But we'll see what the jury does. We'll be right back with breaking news just coming into CNN.
Yeah, John, this season there's a lot of...
SiriusXM, America is listening.
Welcome back to Hannity as we continue with President Donald Trump.
Kamala Harris. Mondale's friend and former campaign staffer Tom Cosgrove tells Axios tonight that while he and his family believed his death was imminent after his calls yesterday with Vice President Harris and President Biden, as well as Bill Clinton and Jimmy Carter, Mondale, quote, perked up after those calls. Vice President Mondale basically is credited with having remade the vice presidency, which Kamala Harris now occupies. The idea that we now take as a given that the vice president will take on all kinds of important policy portfolios, will be in charge of key projects, will be a partner in governing with the president. That whole idea of the vice presidency is credited as starting with Vice President Mondale and with the constructive relationship that he had with President Carter. Mondale was, in fact, the first vice president to have an office in the West Wing. Tonight, former President Carter put out a statement in response to the news of Mondale's death. It says, in part, quote, Fritz Mondale provided us all with a model for public service and private behavior. Rosalind and I join all Americans in giving thanks for his exemplary life, and we extend our deepest condolences to his family. Senator Amy Klobuchar was a intern to Walter Mondale when she was in college and he was vice president. She released a statement about him tonight saying, in part, Walter Mondale set a high bar for himself. For his entire life, he kept passing it and raising it, passing it and raising it. Our world would be a better place if all followed his example. He will be sorely, sorely missed. Senator Klobuchar, thank you so much for joining us on very short notice on this news. I really appreciate it.
Thank you. You know, he was an incredible public service, and I think that probably the words that best capture it are the words on the Carter Library, and they were on the wall, and I was in there one day, and I wrote them down and put them a note in my purse and kept them forever. And it was what he said after they lost the election, and he looked back at their 4 years, and he said, we told the truth, we obeyed the law, we kept the peace. And I think that pretty much sums up Walter Mondale's life. He was a man of incredible strength and dignity. He treated everyone with such kindness, and he went from a tiny little town as the son of a minister in Ceylon, Minnesota, all the way to the second highest office in the land.
Those words that you just quoted, I have interviewed you over the years on lots of different occasions, and more than once you have quoted me those words. I know how important Vice President Mondale was to you. You have often described him as your mentor in politics. Can you talk a little bit about what it was like to be an intern for him, first of all, when he was vice president, but also in what he was like as a mentor and why he meant so much to you?
Well, he spent time with the interns, which was incredible. We were just college students. He had us over for dinner at the vice president's house. I thought I was going to go there and do all these glamorous things and policy papers, and they had me do the furniture inventory. And I crawled over every lamp and wrote down every number. And literally years later, I know two things, and I tell young people these lessons. One, he was honest, nothing was missing. But two, take your first job seriously, because he gave me that first job. And now I've got this one as a U.S. Senator of Minnesota. And he encouraged me while I worked with him at the law firm. He encouraged me to run for the U.S. Senate. He supported me for president. He was there every step of the way. And I think when you talked about Geraldine Ferraro, it wasn't just me. I think every little girl at the time knew that anything and everything was possible, just like when Kamala was standing on that inaugural stage. And I literally still remember what Geraldine Ferraro was wearing with the red dress and her pearls. And he did that. He asked her. He asked her to be the running mate. And he is just someone that has believed that his job, after he left office, after getting defeated, as you so well explained, and running for president, it didn't end there. He saw his job as passing on the torch to the next generation of leaders. And so many people, when they lose political office, just kind of fade away. Not him. He was a pillar in our community, and he stood up for what he always did, and that was the title of one of his books, The Good Fight.
Mm-hmm. As somebody who just embodies the idea of upright decency in public service, ambition, yes, but most of all, solidity decency, a life well lived, and not an enemy in the world. Fritz Mondale, former Vice President Mondale, dying tonight at the age of 93. Minnesota Senior Senator Amy Klobuchar, I know that he meant so much to you. Thank you for being with us tonight. I know it's a hard time, and it's an honor to have you here.
Thank you, Rachel.
All right, Senator Mondale, I should say, well, before he was Vice President, he was Senator of Minnesota, and one of the things I think that is worth remembering at times like this is that his path, as Senator Klobuchar said, from preacher's son in small-town Minnesota to the vice presidency, it's easy to sort of like see the beginnings and see the end in terms of the pinnacles that he reached in public life. But in his time as Attorney General in the state of Minnesota, in his time as Senator in Minnesota, he just built brick by brick a solid, decent, scandal-free record of accomplishment and bravery. He was a senator during the Great Society programs, the Great Society legislation of the LBJ era, of course, and that meant that as a high-profile senator and a leader in his party at the time, he was key to getting so much civil rights legislation passed, to getting so many key environmental protections passed. The reason Jimmy Carter picked him to be his running mate, among other things, was because he was a known quantity and a proven, effective public servant and leader. And as Senator Klobuchar said, even after leaving national office, remained a mentor and friend and pillar, both to his party and to the people of Minnesota, to the very, very end. Former Vice President Walter Mondale died today at the age of 93. We'll be right back.
Sarah! Healthy, sparkly smile she always wanted. Sarah.
Their SUV is always there with them.